Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning to all. Welcome to our third and final day of what's been a busy spring session in Harrisburg.
Or winter session.
Or winter session. Well said. As we begin, we're going to we have no time limits, as you know. We have no rebuttal, as you know. We're going to endeavor to provide about 2 minutes to make sure you can state your theme and what you want to say before questions begin. And then alternatively, when I perceive the questions have run out and the court understands your case, I'm going to very politely ask you to conclude and sit down, and that's for everybody in the room. On the first case, several justices are recused. I'd ask them to leave the bench, and we do have a quorum, so those that are hearing it will stay. You're on? You're on? You're off. And we do have 4, which makes this lawful, and we will decide the case for you. In this is a disciplinary matter. The respondent, a former judge on the Philadelphia Municipal Court, pled guilty in the United States District Court for the Eastern District to the offense of false statements in connection with the willful filing of false campaign finance reports with the Federal Election Commission. The issue before us involves the proper disciplinary sanction to remedy the respondent's violations of the rules of professional conduct. The hearing committee recommended that respondent be suspended for a period of 4 years, retroactive to his temporary suspension. The disciplinary board recommended that he be disbarred. The Office of Disciplinary Counsel, as I understand it, urges that we recommend we accept the board's recommendation of disbarment or impose a 5-year sentence. Respondent appears today seeking a suspension period of no more than 4 years. And so pretty limited issue and a subject that the court unfortunately is well familiar with. With that, Mr. Tinter, you represent the respondent.
I do, Your Honor.
Please feel free to proceed. As I said, we'll give you a couple minutes and then we'll see if we have any questions.
Thank you. May it please the court, my name is Robert Tintner of Fox Rothschild. I have the honor and privilege of representing Jimmie Moore, who is the respondent in this disciplinary case now pending before this honorable court. As Chief Justice Baer said, we're here because the hearing committee recommended a 4-year suspension. The disciplinary board recommended instead disbarment. I requested oral argument, and this court was kind enough to grant it. And following briefing, we're here on argument. I'm not here to tell the court that this isn't a serious circumstance that warrants a long-term suspension. Of course it does. I'm here to plead to the court that it consider all of the mitigation factors at play here. They are substantial. They are in the record, but I will sum them up for the court because I think that they are significant. Mr. Moore was a judge of the the Municipal Court of the Court of Common Pleas of Philadelphia County. He was also a private practitioner. In over 42 years of private practice and serving as a judge, he had never had any disciplinary violation. He fully cooperated with the government. He testified in other matters, particularly related to the scheme in which he was unfortunately involved. He did fully cooperate with the Office of Disciplinary Counsel. He has actually been temporarily suspended by order of this court for almost 3 years. He was completely remorseful. The Office of Disciplinary Counsel will tell you differently, but the hearing committee found his testimony to be credible and that of his character witnesses, and it was noted in the hearing committee report. It was actually referenced also in the disciplinary board recommendation. The conduct at issue did not involve the practice of law, and I'm not here to suggest that this court should not discipline attorneys because they commit a crime and it has nothing to do with the practice of law. Of course they should. But it did not, and he did not use a political position. And I say that because the Foreman case, which is the case primarily relied upon by the disciplinary board, did involve somebody who used his political office to commit the crime. I think that is substantial because it does affect certainly this court's interest in protecting the integrity of the system, but also the public at large. He had outstanding character witnesses who were believed.
I think your 2 minutes have passed, and so let me start the ball
Certainly.
rolling here. This is just a question of pure curiosity. Are all Philadelphia Municipal Court judges permitted to engage in private practice simultaneously?
No, it wasn't simultaneous, Your Honor. I apologize.
It was
There were
before and
periods,
after.
correct.
You said he was remorseful.
Yes.
In my reading of the record, he was remorseful once he got caught, which is pretty prototypical. What's bothersome here is that he was aware that he was under FBI investigation. He was aware, I think, that the weight of the federal criminal prosecution was going to drop on him for months and months, while he never disclosed, applied for, took senior status, and sat as a judge. And that's offensive to all of us. That doesn't mean that we're going to personally punish him, but those are bad facts for the Pennsylvania judiciary.
Understood, but I believe what the record will reflect, and it's a slight timing issue, is that he assumed senior status from the municipal court when he knew that the indictment would be made public, and that at that point he knew he intended to plead guilty. So, I'm sorry, Your Honor.
There lies the, let me finish, then I'll give Justice Donovan. In there lies the egregiousness of this, and the question of his remorsefulness. And I don't want to beat him up, but the facts are the facts. In April 2017, the FBI contacts him, and he agrees to cooperate. He does not notify AOPC
Correct.
that there's a criminal investigation. He remains every day on the municipal court. He notifies ODC that he retires from the judiciary on September 11th, and on September 13th, he pleads guilty.
correct.
So it certainly appears that from April to September, which is more than a few days or weeks, he compounded his problem by continuing to sit as a judge while under investigation or working with the FBI. And you tell me why I'm wrong.
Well, I'm not saying that you're wrong, but, Your Honor, to clarify and to just make the point, being under investigation did not mean that he knew that he was going to be indicted or that he would plead guilty. And
Please do.
We now have a rule, and my question to you is a timing one. We now have a rule that requires a judicial officer to advise AOPC when he or she becomes aware that they are under investigation. Was that the rule?
I
When
do not believe so based on the questionnaire that I reviewed. I don't know the rule, but frankly, I would support that rule and I would agree with that rule, so
To me, that's critical. I mean, because, we instituted the rule because your client wasn't the only judicial officer who
Understood.
was aware that they were under investigation and didn't report to AOPC. So, and maybe Office of Disciplinary Counsel can help me with that, because if we had the rule in effect and it was just blatantly disregarded, that's one thing. If we didn't have the rule in effect and he was going under the current thinking at the time that
But also,
didn't have to report.
there's a timing issue, which is reflected in the record, which is, I agree with you. When he knew, he should have at least updated his application, if his initial application was correct. I don't dispute that. Mr. Moore does not dispute that. That was a mistake.
How old is your client?
How old?
Yes.
He's in his 70s, and he is...
You know, like how we're in his 70s, those of us who are close to that age consider every one of those years to be of critical importance. So as I looked at the record, I thought he may be 71 or 72. Is that close?
That's correct. I think he's 74 at this point.
Oh,
but
okay.
I would like to make that point, because you raised the age factor. I mean, Mr. Moore does not intend to practice law again. I mean, clearly that is not why I'm here. I'm here because there is a certain level of importance, obviously having been a lawyer for 42 years, a lawyer and a judge, and I do believe that this court should and implement appropriate compassion and understanding for what I would still define as something aberrational in this man's life and career, and I think the record reflects that. He would otherwise get no second chance, and I do think that that's important, and I think the precedent, just to get back to, is consistent with a long-term suspension. Even for somebody, there's no question, he was a public figure, there was limited publicity, but there was publicity. I acknowledge all of that, but I would respectfully request that when the court looks at the record, looks at his testimony, which I do think showed genuine remorse, that the more appropriate discipline here is a long-term suspension, and I would simply point out that that's what the Office of Disciplinary Counsel requested that the hearing committee do. And I think that the hearing committee did an excellent job of analyzing the cases and applying the mitigation appropriately, consistent with this court's precedent.
And he testified before the hearing committee. The board, as it is incumbent on them, reviews the record.
That's correct, Your Honor.
Okay.
They did.
Okay.
You mentioned,
I just have a quick question.
Yes, Justice Mundy.
Your client know that he was under investigation at the time he prepared the application to serve as a senior judge?
I don't believe that he did.
Okay. And I see he started to serve in December of 2016.
Correct.
So it's, to the best of your understanding, it was after that point.
That's absolutely correct. He had done several stints once he stepped down from doing senior status from here to there. So there had been other periods as well before, but that is correct.
Counsel,
I'm sorry, go ahead.
is your client, is he retired or is he employed in some other endeavor?
No, he's not employed at the present time.
And you're telling us that he does not intend to practice law. He wants to maintain his law license because he was proud to be a lawyer.
That's absolutely correct. He would like to, yes, at some point after his discipline hopefully is resolved, he would like to at least regain his status. Correct.
And to call himself a lawyer, not practice law.
That is correct.
I mean, obviously he can practice law. I'm just trying to understand
Of course.
the parameters of the situation.
And I suppose he would not rule out some legal law services that might be related to community service in the future, but certainly not the private practice of law, Your Honor.
Okay, thank you.
And this is in furtherance of Justice Mundy's question. And again, I'm not trying to beat him up. It's the nature of the case that you have to inquire into these matters. In June, he distributes 90,000 purchases with his campaign manager, I assume girlfriend.
Yes.
A Cadillac, and takes a couple vacations, which for money that others involved thought he was going to pay campaign debts. He did pay some campaign debts. And then did that in June, and then in November of that year, certainly well aware of the misconduct, I presume hoping he was going to get away with it, he applied to AOPC, and he said there was no pending investigation by law enforcement. That may be technically accurate, but he certainly had some chutzpah getting back on the bench as a judge after committing these acts.
Understood, Your Honor. He certainly knew the circumstances of what had happened. There's no question about that.
And I think finally for me, maybe it's like time served, there's nothing wrong with it, but I'm a little bothered that he's been on suspension for 3 years, so that if we accede to your request of a 4-year suspension, by this time next year, he could be back at the bar.
Well, the reinstatement process, Your Honor, takes at least
That's true.
6 to 9 months, and frankly, as I've said, he has no intention of practicing law. I think he would just like to finish out the process, much like he did with his probation and paid his fine, and put this horribly aberrational matter behind him and get a second chance.
Counsel, I was going to ask ODC to do this, but maybe you could assessed. We understand why it's critical, the critical difference between a suspension of 4 or 5 years and disbarment, but we have people who watch our oral arguments and they may not understand why it makes such a big difference to an attorney.
Certainly. Well, the notion of disbarment is you are being removed from the practice of law. You can certainly apply, but unlike in a long-term suspension where you can at least begin the reinstatement process at the conclusion of that, you can't with a disbarment. You have to wait.
7-year period? for
I believe
disbarment?
it's 5 years, full 5 years, but then you can't even start the reinstatement process. But I mean, I think also very critically is the stigma of disbarment, which,
I think there's also a presumption, presumption may be too strong a word. ODC can explain it to us.
Yeah,
But I think that that's easier to get back into from a suspension than a disbarment.
certainly it is.
That's why I think it's, obviously we may not quite understand it, so maybe not only for the listening public, but it might be helpful for us to be reminded what the critical difference is.
Understood, Your
Okay,
Honor.
Thank you.
Thank
Attorney
you.
Brobson, Attorney Brobson. Justice Brobson, anything?
Still a lawyer, Chief. I'm just a justice by luck.
Yeah, that's absolutely right. Nothing?
I just, the conduct in question occurred in 2012, 2013.
I believe that is correct, Your Honor.
And so there was a period of time, do we know when the investigation started?
We don't, Your Honor. I mean, I certainly don't. I do know that there were obviously other components to this puzzle that the United States Attorney's Office was looking at. Mr. Moore was a piece of that. There were other pieces, and there were other criminal indictments and convictions that came afterwards in which Mr. Moore, well, I should say contemporaneously, because Mr. Moore testified in those. So I think there was a substantial period of time. And again, I don't want to diffuse the questions of Justice Donahue and Chief Justice Behr about Mr. Moore knew that he engaged in a wrongful act. I'm not so certain when he knew that he was being investigated or that he was going to be part of that. But nevertheless, he took full responsibility and knew that he had done something wrong, that it was criminal, and that ultimately he would plead guilty and cooperate both with the government and the Office of Disciplinary Counsel.
Was there an order of restitution?
There was no restitution. There was a small fine and 2 years of probation.
You got to keep the $90,000.
Well, most of the $90,000 was money that had been contributed by Mr. Moore, Ms. Cavanis, and some of the campaign debt. So a lot of the money went to repay obligations, including, and there was within that, not that it's important for this purpose, but there was a legitimate purchase of polls that had been done, that the other campaign purchased.
Well, but the victim, this is not there was no victim to give restitution to. The money that was paid to him was voluntarily paid by another political candidate and candidate's campaign.
Correct.
So there's no victim.
Well, the victim was the public. and
Right,
that's-
well, other than that, right, I
Yes.
understand, but I don't know how you restitute the public in
Correct.
this
And that's, I
situation.
think, why Judge Du Bois ruled the way he did.
This was a multifaceted, voluntary violation of campaign finance laws.
That's correct.
Yeah.
That's correct, Your Honor.
Thank you.
Do you have anything further? Go ahead. If not, we understand the case.
No, only to summarize and respectfully request that the court impose a long-term suspension in this case. Thank you for your time.
Good morning. May it please the court, I'm Harriet Brumberg, an attorney with the Office of Disciplinary Counsel. We're here today opposing respondents' challenge to disbarment, to the disciplinary board's recommendation for disbarment. The disciplinary board got it right. Respondents' long-term pattern of dishonesty and deceit to the electoral process, to the judicial system, and to Office of Disciplinary Counsel itself shows that he's a danger to the public and a dishonest person. Disbarment is necessary to restore faith to these institutions damaged by respondents' deceitful conduct. This is a long-term pattern of deceit. It did start in 2012 after respondent withdrew from being a municipal court judge, when he agreed to take $90,000 from another political campaign, knowing it was wrong to take the money from that campaign. Then what did he do? He created a bogus company, false invoices, and filed knowingly false returns with the Federal Election Commission. And he corrupted another in doing so. That wasn't enough. That was in 2012 and 2013. And then in 2016, what does he do? He applies to be a senior judge, knowing he had committed these campaign violations.
Well, but I'm interrupting. I apologize, Chief.
Go right ahead, Justice.
You could interrupt.
Well, I'm trying to observe this 2-minute rule.
Oh, all right.
It's more of a guideline. Go right ahead.
All right. So I will continue, or I will hear you.
I'm trying to understand your premise. Is he being held responsible because when he applied to be a judge, he didn't disclose his various foibles? I mean, is that something you're required to do, is saying, I understand, I'm not trying to minimize what happened here. What he did was serious. I'm just saying that, is there an obligation when you apply to be a senior judge to disclose everything you've ever done that was bad, that you didn't get caught for and haven't been investigated for yet?
No. So let me, I will break it down into little parts for you. You have the application from the AOPC. The AOPC says, have you ever been investigated for any crimes? And he checked no, because at that time, purportedly, he did not know, all right? And he does sit on the bench. The first problem we have with him sitting on the bench is he knew he committed a crime.
Yeah, but okay, hold on for a second. So there's no question on the questionnaire, though. It says, are you under investigation? It doesn't say, have you, in your mind, committed a crime, but not been investigated, not been charged, and not been convicted. Is that something you're required to disclose?
You are required to disclose the crime if you've been convicted of a crime.
Right, but he wasn't convicted. He wasn't under investigation. He did something he knew was bad, he knew was wrong, and if he was charged, he was probably going to be convicted.
The form also requires you to disclose if there's any change in circumstances to any of the questions. So the question is 10. I'm going to read it out loud so we're all clear. Is there, to your knowledge, any pending investigation against you by the Judicial Conduct Board or any local, state, or federal law enforcement agency? And he checked no.
Which you agree was
Which
true at the
is
time.
Correct.
But counsel, I'm not disagreeing with the idea that he probably should have updated that question. I'm going to what your argument was at the beginning, which his first mode of deceit for which you want us to hold him responsible is when he filled out that application, even though he was truthful in saying he wasn't currently under investigation, he should have gone to some place where there's some extra space to write. I'm not currently under investigation, but I know that I did something really bad, and I'm disclosing that I did it.
Or he should have looked into it. As you know, Canon 1.1 requires judges not to violate the law.
But why are you prosecuting a Court of Judicial Discipline matter?
I'm not. I'm just showing a pattern of deceit.
Sure you are. I mean, were charges brought against Mr. Moore by the Judicial Conduct Board?
Not yet. I can't tell you what's ultimately going to happen.
Well, I would hope you wouldn't know, because it's supposed to be confidential.
Yes,
Exactly.
yes. So I don't know at this point. However, let's continue with this point.
Ms. Bromberg, let me just mention to you that his Fifth Amendment rights are not suspended by virtue of being on the judiciary. Now, he's obviously in an awkward position because if he fills that form out, I decline to answer on the grounds that it may incriminate me. We're in a thorny area of the law. Is it civil, and can you draw an adverse inference? Is it administrative? And I don't know if you can draw an adverse inference. My guess is if he invokes the Fifth Amendment, we probably don't exercise our discretion to make him a senior judge. And yet, you're not supposed to have adverse consequences, at least in the criminal world.
It is an awkward position. I don't disagree. But he did sign this form. He had an obligation, at least to the AOPC. And it reflects on his character, the content of his character.
Let me ask you that question because,
Yes.
we struggle with this.
Yes.
All the time in these cases.
Yes.
I mean, it is uncontroverted that this gentleman had an unblemished prior career. So it is. I mean, up until 2012, I don't see anything in the record to suggest that he was either disciplined or, otherwise did anything that brought the profession or the bench into disrepute. My question to you is, why are you so convinced that what we're dealing with here is a episode that defines his character as opposed to an aberration?
Thank you for asking that. I would like to continue with why I feel it's a pattern of dishonesty.
No, that's not my question. I'm asking.
I don't think it's aberrational episode at all. And where I'm going with this is his conduct to Office of Disciplinary Counsel speaks loud and clear how he views what he did. He wrote a letter to Office of Disciplinary Counsel in which he said that he violated the campaign finance laws, and he did not know at the time he did so, and this was an accommodation to the congressman that he was running against. Number one, he knew at the time that he agreed to take the $90,000, that it was a violation. He testified to that under oath at federal court. I knew at the time it was basic federal law. I cannot take $90,000. He wrote to ODC to report his conviction and said, I didn't know. And then he lied and said that he did it as an accommodation for the congressman. It wasn't an accommodation to the congressman. It was an accommodation to the respondent who was in debt.
Oh, hold on for a second. Look, there were a lot of people involved in this scheme, and he is paying his price for being involved in that scheme. But to suggest that other people didn't benefit from him getting out of the race is not a very fair assessment of the circumstances.
I'm not saying he did not benefit or they didn't benefit, but
You did just say that. You just said
it was
he
not an
benefited.
accommodation for other people.
Sure it was.
It was an accommodation for himself as well.
Justice Robson ask you the question, and then you can answer.
That's, I'm, it's not as much a question as it's an observation, I hate to use phrases like gild the lily or anything like that. What he did was bad. There's no doubt about it. I think you're trying to make it sound worse by making it sound like he did it alone. Sure, he lied. He was confronted with being charged with a crime. He was worried about his future. He was worried about his. I get it, and he should be held accountable for that. But I feel like I don't even know if you believe that he should be permanently suspended, because as I understood it, there's some disagreement within this disciplinary board. But I'm trying to ask you this question.
Yes.
If you're a hammer, everything looks like a nail. And where are you going to go from here? If what happens here is this man gets disbarred for what I think Justice Donahue correctly observed was a period of time, multiple events within a period of time, of an otherwise unblemished career, everything's going to look like a nail, isn't it?
No, I don't think it was a limited period of time. And if you would let me continue and explain, because then he tried to distance himself from this to Office of Disciplinary Counsel. As I said, originally he wrote to us and said, I did not know it was a violation of the campaign finance laws, when in fact he testified to the opposite. And then, in his answer to the petition for discipline, he lied at least 4 separate times. One, he lied and said he did not know it was wrong to take money at the time. 2, he said he did not know the source of where the money came from, when in fact he testified he knew the money came from another campaign. 3, he lied and he said, I didn't have anything to do with how the money was distributed, when in fact he testified how the money was paid to the different loans that were given to him. And we have emails, which are part of your exhibits, that shows he was part and parcel of how the money was distributed. And 4, he lied in his answer to the petition for discipline and said he didn't have anything to do with getting the money personally. He denied that he used the money, and he was impeached with that at his discipline hearing, in which he admitted he did use the money for vacations to Florida and to Canada and to buy a new car. So it's this accumulation of conduct from 2012 to 2020 in which he denies, deflects, and deceitful. And I think this is a case where we need to send a message to the public, someone who has damaged these institutions of democracy, the electoral process, the judicial process, and Office of Disciplinary Counsel, and made deceit.
What judicial process?
Ah,
He wasn't a judge at the time. He didn't use his official capacity as a
he's
jurist.
sitting as a judge in judgment of others,
No, but
and
I'm
knowing
talk-
he committed a crime.
Counsel,
I
I'm talking
find-
about, hold on for a second.
Yeah, let the justice
Yeah.
ask.
Knowing he committed a crime, you know, you commit a crime when you're convicted of a crime.
Right?
Right. He wasn't convicted of a crime yet. But I'm just saying, did he, unlike Feast, unlike the other cases that you're relying on where there was a disbarment of a public official for using their power and their authority to benefit themselves, there is no allegation in this case that he used his power and authority as a judge to commit a crime. And you are equating his conduct as a private citizen to the conduct of public officials who used their power to commit a crime.
I'm equating the fact that here is this man sitting on the bench judging others, knowing he has committed a crime and knowing he has a duty to report. I think the disciplinary board summed it up perfectly and concluded the blatant hypocrisy of the situation is astounding and serves as a serious aggravating factor.
Why isn't that a matter for the Judicial Conduct Board and the Court of Judicial Discipline?
Office of Disciplinary Counsel likewise has jurisdiction over attorney misconduct. In order for him to be a judge, he has to be an attorney.
May I ask you, and given that dialogue, it may seem silly, but opposing counsel said that at least once he was caught, and the jig was up, if you will, that he was remorseful and cooperative. Do you disagree with those?
I do disagree with that. I think he was remorseful only for himself. We have never heard to this day an apology to the electoral process, the judiciary, or to Office of Disciplinary Counsel.
How would he do that? Or would he?
Because he only expressed remorse. This has hurt me personally. You could look at what they did in Foreman, in Presky, and in many other cases where people realize they've tarnished the reputation of the legal profession. He tarnished it. It was in the press all the time. This was a judge. This was a lawyer.
Got it. I'm questioning your premise that the Office of Disciplinary Counsel has concurrent jurisdiction with the Judicial Conduct Board.
We do not have concurrent jurisdiction, but we have jurisdiction over attorneys for their misconduct.
When a person becomes a judge, their license goes into suspension. You have to reapply.
Correct.
There is no concurrence between the jurisdiction of those two bodies. So,
You're right.
And so, you know, Justice Brobson's question is why are you, your reliance is on activities that, in your perception, that he committed when he was sitting as a senior judge?
Just to put it in perspective, I'm saying this is a reflection on his character, his dishonesty, the deceit that he has. I'm not.
You do not believe it's aberrational in answer.
I do not. I do not believe it's aberrational.
Would you, before you sit down, answer Justice Donahue's question from before? What is the distinction between a 5-year suspension and a disbarment?
There's a very large distinction. In disciplinary law, there's a case ODC versus Keller, and they've established something called the Keller threshold, which one must overcome at a disciplinary hearing for disbarment, and you have to show that you've substantially rehabilitated yourself above and beyond the kind of rehabilitation that you would show in a suspension case. So it's something that's harder to overcome. Also, disbarment sends a message. We need to send a message to the public and the profession and the electorate that this kind of conduct can't go on.
It just depends upon the extent of the message. If somebody gets life without possibility of parole, it's not the death penalty, but it still sends a message that society deals with the crime seriously. And here, you know, the parameters are 2 years, 4 years, 5 years, or disbarment. They all send a pretty good message.
I believe that disbarment sends a stronger message.
Well, of course it does.
Yes, so, and that's...
We got it.
And wait. So I'd like to just respond to a couple of things respondents said, but go ahead, you have a...
Do you give Mr. Moore any credit for his agreement to plead guilty immediately after finding out about the formal indictment, and the fact that he went on to assist and cooperate the government in the prosecution, including wearing a wire?
I give very little credit because it was in his best interest to do so. Every criminal defendant knows that it's in their best interest to cooperate, and once you're caught, to cooperate. Did he come forward and cooperate? This court has given credit and noticed when people come forward and cooperate before they're convicted. Look at ODC versus Greenberg, ODC versus Perone, in which we say that had respondent come forward earlier, we would have known he recognized his wrongdoing. In Office of Disciplinary Counsel versus Stern, we criticized Mr. Stern for only cooperating after he was caught. So yes, once he's caught, he cooperated, but at no time, even though he knew he committed campaign finance law violations, did he come forward. So he gets very little credit. Clearly, he cooperated greatly given the sentence that he got. Similarly, I give very little credit for his years of community service, given that it was dissipated by all his misconduct from 2012, 2016, and 2020.
32 years worth of unblemished service, you're just going to erase that?
I'm not erasing it, I'm undercutting it by showing the substantial aggravating facts that we have here. This was done purely for his personal greed,
Ms. Brumman.
and he corrupted another.
You've argued your case passionately and well. We understand it. If you don't have anything new to add, we can take this under advisement and move on. You have anything else you want to say? I don't want you to sit down and say, well, he cut me off.
Well,
Well, I guess I do if you're
well,
done.
I just want
Go
to
ahead.
say one thing. Respondent accuses Office of Disciplinary Counsel of being punitive and unfair and unsympathetic. You know, he called me.
I said it.
You called me a
I
hammer.
suggested if you're a hammer, everything looks like
Right.
a nail.
I just want
And
to
you
make.
take that as a compliment.
Well, I was just going to say, Office of Disciplinary Counsel is not in the happiness business. We're not in the business to make attorneys happy who we believe are dishonest.
I'm sorry, Chief. I guess my point is, and this is my first disciplinary case as a justice, okay? So you have to bear with me a little bit. I thought it was interesting that the disciplinary board at multiple different levels of the process came up with multiple different penalties for this particular thing, and that the hearing board that actually heard the case, heard the evidence, saw the witnesses, came up with some completely different than what the board decided ultimately on a cold record.
Right.
So and I don't even think disciplinary counsel agreed with a disbarment. I think that's, as someone who's doing this for the first time, I think that's really interesting.
Okay, well, I'd like to educate you about that. You're absolutely right. The hearing committee did hear, and this is the determination. The beauty of the discipline system is that it's de novo review at each and every step of the way.
I'm not sure how beautiful that is, but I'll reserve my judgment on that.
And when we received the disciplinary board report, I knew I'd be up here one day. I knew I'd have to say, we got it right, should be 5 years, or the disciplinary board got it right. So what did we do? We went through and read the record over and over. We weighed the evidence. We reread the report from the disciplinary board and found it very persuasive. And then we saw respondent's brief in which he deflects responsibility, blames it on everybody else. He demeans Office of Disciplinary Counsel. He, debases the current case law that we have. He doesn't see how he could be
Called
a danger.
distinguishing case law. Every single attorney who comes before us distinguishes case
Right,
law.
right.
So, but thank you.
Right, right. All right.
We do have the case. Thank you very much for your passionate argument. Thank both sides, and we'll move on.
Thank you.
All right, we're going to take a minute or two. Our colleagues join us and get ready to hear the next case. Betsy, can you ask the other justices to come out? A lot of people to watch that one. Brian?
Clean Air Council et al. Versus Sunoco Pipeline. Representing Clean Air Council is Mr. Alexander Baumstein. Representing Stephen and Ellen Gerhardt is Mr. Richard Raiders. Representing the DEP is Mr. George Yugovich Jr. Representing Sunoco is Mr. Robert Fox.
This case is not amenable to a quick paragraph, at least apropos of the facts. So we're going to rely upon you to some extent in that 2-minute window that we give you more or less to make sure we understand fully what's occurring. My understanding is that we granted allowance of appeal in what are two procedurally complicated cases and consolidated them to consider the proper standard of review to be employed in awarding counsel fees, if any, against a private entity, here Sunoco, in accord with Section 307B of the Clean Streams Law. And one of the difficulties in central tenets is that that section doesn't provide the standard of review. So if that is good, feel free to supplement. And Mr. Baumstein, is that correct?
Yes, sir, Baumstein.
Baumstein, I apologize. Please feel free to go forward. We have, are you the only two lawyers arguing? No. Okay. They have 3 on their side, and just me. We'll leave it be for now, but be advised that we don't want to conclude our careers on this case. And so, politely, we're going to insist that you don't just repeat each other and you have new information to provide. Mr. Baumstein, please go ahead.
May it please the Court, Mr. Chief Justice, Your Honors, my name is Alex Baumstein. I'm here on behalf of Clean Air Council, the Delaware Riverkeeper Network, and Mountain Watershed Association. Per the court's instruction, because this is a consolidated appeal or consolidated proceeding, I will explain which counsel will address which issues up front before I begin my argument. I will address the court first, followed by Mr. Rich Raiders on behalf of the Gerhardt family, and Mr. George Yugovich on behalf of the Department of Environmental Protection. The public interest groups are party to 73 MAP 2021, so I will address any questions regarding the facts, proceedings, and interpretations of the opinions in that case. I'll explain why the adoption of the bad faith rule by the Environmental Hearing Board was an error of law, inconsistent with this court's precedent, and that the proper standard of appellate review in this case is de novo. In turn, the Gerhardt family is party to 74 MAP 2021 only, so Mr. Raiders will handle questions specific to that case and the opinion below. Mr. Raiders will argue that the EHB should not have departed from its longstanding Qualwasser test for cases that ended in adjudication, as the Gerhardt case did, and will discuss apportionment of the fees that were already awarded in that case. Finally, the department is a party to both appeals, so Mr. Yugovich can handle any remaining questions relating to either case. He will argue that the new bad faith rule conflicts with the text and the purpose of Section 307B and misunderstands the roles of the parties.
Do you have other co-counsel with you at counsel table? Could you introduce them?
Absolutely, Your Honor. So Mr. Paul Cohen is also with Clean Air Council, and Ms. Catherine Urbanowitz is with Clean Air Council as well.
You may
Thank you.
have set a record for confusing me in the number of seconds since we began, but hopefully it will unravel as we proceed.
And let me see if I could understand. We are going to hear about the bad faith standard that was actually applied until the last argument? Oh, I'm sorry. My question, I'm sorry. So I understand, we aren't going to hear about the bad faith standard that was actually applied in this case until the last argument?
Yes, Your Honor. Yes, we will hear. If you intend to mean that multiple counsel will discuss that rule, yes, that is the case.
Okay.
Go forward. Go ahead and begin your argument.
Thank you, Mr. Chief Justice. Your Honors, this appeal presents a straightforward question of statutory interpretation. When can citizen appellants, like my clients, recover fees from a permittee, like Sunoco here, under Section 307B of the Clean Streams Law? The EHB answered that question here by inventing a new legal rule. The citizens are eligible to recover fees only if the permittee engaged in bad faith or vexatious conduct. That new rule is inconsistent with the broad language of the statute, with this court's precedent interpreting such language, and with the policy enshrined in the Clean Streams Law. In the case below, following drilling fluid spills in which Sunoco contaminated streams and drinking water supplies, we won 2 successful settlements with Sunoco, in which Sunoco agreed to dramatic changes to several construction plans that are incorporated into the permits. What resulted was on-the-ground improvements for communities, like enhanced scientific study at scores of drilling sites, better drinking water testing for at-risk residents, and strengthened spill response protocols along 300-plus miles of pipeline work. My client then sought a reasonable fee award under Section 307B for fees and costs we had incurred in order to win those 2 settlements. But instead of applying the long-standing catalyst test, the EHB adopted a novel bad faith rule. Because the EHB did not find bad faith, it stopped its analysis right there, denied fees as a threshold matter, and never even reached the facts in our case. But this new rule flatly contradicts this court's precedent. And I would direct Your Honor's attention to Lucina versus Commonwealth and Solberry Township versus DEP. These are the cases in which this court has interpreted Section 307's fee-shifting provision. The latter, the Solberry Township case, being a decision by former Chief Justice Saylor, in which Mr. Chief Justice Baird joined. In each instance, the court heard argument that a new rule should be created.
We are 2 minutes in. I want to alert the court to the extent that they want to ask questions, and I'll start the ball rolling. And again, in all seriousness, perhaps I misunderstood in my prep. If I understand what you said in your beginning, this is about fees in which you proved that Sunoco damaged the environment through their actions and vindicated that by getting redress of those damages, improving the environment. Is that what you said?
That's correct, Your Honor.
And as I went forward, I thought the case was about Sunoco seeking permits, 20 permits, for the Pennsylvania pipeline project, and your clients opposing the grant of those permits. Did I just get this fundamentally wrong?
No, Your Honor. Let me clarify, if you would. So our clients appealed these 20 permits to the Environmental Hearing Board. Just going through the facts. We sought a supersedious at the Environmental Hearing Board level. And during the Environmental Hearing Board judge granted a temporary supersedious relating to the drilling for the pipeline construction. During that period, we entered into negotiations and ultimately a settlement agreement with Sunoco, which was then approved by the Environmental Hearing Board as a stipulated order.
And again, let me interrupt you so that we can all understand what our facts are, because facts change the result. Is your settlement about prior damage to the environment by Sunoco, or is it about Sunoco's seeking these permits in your opposition to them? Or maybe both?
Your Honor, I think you hit the nail on the head with it's essentially both. It's a little bit complicated, but to make it as simple as possible, the supersedious that we sought related to the fact that the permits allowed construction in a certain manner. And in the course of beginning that construction, doing it in that manner led to direct harm to the environment, being contaminated drinking water supplies, etc.
And again, and I don't want to dominate this. I know Justice Doherty has a question also. But I thought you got a supersedious from the EHB that precluded them from doing the construction where somehow now they harm the environment. So straighten that one out for us.
Yes, Mr. Chief Justice, that is correct. Right? So we got a supersedious, a temporary supersedious from the EHB that stopped construction of a certain type of construction, horizontal directional drilling, during that time while the EHB was considering our request for a longer-term supersedious. And that was related to and directly after we started observing all these harms that were caused by construction under the permits. Does that clarify things?
So just to, again, just make sure I got it, and I want to make sure we all have it. Your claim here today is for fees for damages Sunoco did before you got a supersedious and stopped them, and then additionally for whatever monies, attorney fees were spent in the permitting process because you were able to impede their getting these 20 permits. Both.
Well, just to clarify, in case there's any, and please let me know if I'm hitting the nail on the head here, but we're not asking for fees relating to damages done, because the Clean Streams Law has enforcement provisions. This is not an enforcement case. This is a permitting case. However, the aspect of the permitting for which we are seeking fees relates to damages that were done. Does that clarify?
Yeah, well, I'm glad to hear that because I think it's a unanimous no. So.
My note is that in the Clear Air Council entered into a settlement with DEP that Sunoco was not a part of, yet you're looking in this action to seek council fees from Sunoco regarding a settlement that they weren't involved with.
Your Honor, respectfully, that is not accurate.
Okay.
So, absolutely. So, and I can do so by reading directly from what we asked for. We asked for, well, We asked for, and this is in the record, this is in our fee petition, it's also in the Environmental Hearing Board's decision. We asked for fees for 2 settlements that we had with Sunoco. We did not ask for fees. We were very explicit about this. We did not ask for any fees relating to our settlement with DEP. I know there was some confusion in the Commonwealth Court opinion relating to that. However, as a clear matter of the record, and there's really no muddling the record itself, or the EHB opinion, which recognizes very clearly we were seeking fees relating to 2 settlements with Sunoco.
Could I ask you about that, counsel? The talk about asking for fees in connection with settlements leads me into the area of the statutory language by which the legislature conferred discretion on the EHB. And the legislature did not say prevailing party. It said the EHB in its discretion. So you reject the bad faith threshold that EHB wants to have. Does the language mandate that the discretion become a prevailing party standard, number one, and if so, what's the basis for importing that? And number two, even if it did, how are courts reviewing those decisions to even figure out how one would deem somebody to prevail, given that settlements are premised on give and take?
Great questions, Your Honor. So this case is controlled by the Solberry case of this court previously, Solberry Township. And that was very much the question in Solberry Township, is we have, in that case, there was not a final judgment on the merits. There was not an adjudication at the EHB. And this court said that it was error of law for the Environmental Hearing Board to too rigidly apply the Qualwasser test and not allow for fees as at least a possibility under what turned out to be used as the catalyst test. And on remand, the Environmental Hearing Board applied what it then called the catalyst test, and this is a catalyst test case. So that was 15 years ago or so, and the EHB has consistently applied that since. At the Commonwealth Court level, indeed, the Upper Gwinnett-Towamencin case affirmed the Commonwealth Court's use of the catalyst test where there is not a party that prevails at an adjudication.
Okay. So it's a threshold matter.
Yes, Your Honor.
Counsel, I'm going to ask a real basic question.
Please, Your Honor.
The proceeding before the Environmental Hearing Board, was Sunoco a party?
Yes, Your Honor.
So it's your client versus DEP and Sunoco?
Yes, Your Honor.
Okay. You could see the basic level that I require information about here.
No, I really appreciate these questions, Your Honor.
And you know, I said at the outset, I'm with Justice Donahue. We're figuring out who's on first before we worry about second. But you've moved us forward. Obviously, we'll have to hear from the other side. So why don't we take the catalyst test, which we all understand, we're a very hot court, and see whether you get fees under the catalyst test. So the opposing party, Sunoco, and it had to provide some benefit to you as the requesting party that you sought in the underlying suit. And again, this is apropos of Justice Mundy and Justice Donahue. Because I was of the same position, why are you bothering Sunoco? You settled with DEP, and they had no control over anything. So what benefit did Sunoco give to your clients that entitles you to fees from them?
Absolutely, Your Honor. So here, it was Sunoco that agreed to the dramatic changes to the construction plans that are incorporated into the permits. What resulted here was improvements for communities on the ground, enhanced scientific study at drilling sites, better drinking water testing for at-risk residents, strengthened spill response protocols, other things, reevaluations of drilling plans in order to make sure that going forward those plans are more protective and less likely to result to harms to individuals. These were sweeping changes. And what resulted from that is many scores of reevaluations of how drilling was going to go forward. That dramatically improved the protections for people, for the public broadly, for water supplies, for streams. These were huge concessions of Sunoco. And I would submit, Your Honor, that it would be unfair to take these huge concessions from Sunoco and say only the department has to pay fees for that.
And that's the nub of this case, is it not? I mean, if we were talking about fees assessed against DEP, there wouldn't be a question here. This would be a catalyst test case. But the board distinguished between a permittee, part of a private enterprise, part of the industry, paying fees pursuant to that test, and fees assessed against a taxpayer entity. Why were they wrong?
Your Honor, that's a great question. So
That's what this case is about. I mean, we know what all these tests are. The question is, do they apply to Sunoco?
I agree.
Permittee?
I agree, Your Honor. There is no textual distinction between the government and the permittee who are on the same side of the V here. You have to look to how this language has been interpreted over the course of many years. So there is 25 years of precedent that there is a different standard applied when a third-party appellant, when fees are requested from a third-party appellant. This, in contrast, is a novel rule for the first time saying that despite the department and the permittee both defending the permit, there should be a distinction between how fees are assessed against them.
Counsel, permit me, your 25-year precedent, are you meaning Solberry?
This is the Alice Water Protection line of cases from the Environmental Hearing Board, Your Honor. And the motivating distinction, the reason there is a difference at all among the parties is that 307B is the policy purpose behind it is to incentivize under-resourced third parties to be able to bring meritorious claims in furtherance of the goals of the Clean Streams Law. There are literally decades of precedent interpreting this type of fee provision as exactly that, as we need to ensure that people bring meritorious cases to protect our waters. There's no such policy equivalent on the other side for defending against these appeals.
So may I ask, oh, I'm sorry, go ahead.
Just in follow-up to that, under the fee-shifting statute, and I think this is also a nub of this issue, the board has discretion. In its discretion can award fees. And here they're saying, in our discretion, we're making a distinction between private industry permittees and the Commonwealth. Why is that wrong?
Your Honor, this again goes back to the Solberry Township decision. So it's absolutely the case that looking at the facts, the Environmental Hearing Board can apply its discretion, and then the opinion based on those facts are indeed reviewed for abuse of discretion. However, in statutory interpretation, and this is footnote 8 in Solberry Township, statutory interpretation questions, including interpretation of 307B, those are always reviewed de novo.
And I happen to agree with you that this is a de novo review because we're looking at what does the statute allow, but let me return you to Lucchino versus DEP, 2000 decision. You know, this is Lucchino is bad facts make bad law, kind of in a oddball situation. But that court, I mean, clearly said in Lucchino, the board didn't even have to look to other regulations or other law. They could merely rely on that statute that says, in their discretion, they could do what they did, which in that case was to just look at the face of the case, and it was just clear bad faith litigation. Is that holding in Lucchino limited to a situation where you actually have bad faith litigation, which in and of itself is a reason to award attorney's fees, or does it mean what others seem to think it means, which is they could do whatever they want to do under the statute.
Yeah, great question. So Lucchino was an instance in which Mr. Lucchino was asking this court to say that there needs to be a hard and fast rule that there can never be fees against a third-party appellant.
This is Mr. Lucchino, who voted to approve the permit and then sued to prevent its enforcement.
Yes, Your Honor.
Bad faith litigation on its face, according
Precisely.
to the board and the court.
Of course, Your Honor, yes. And this court rejected that statutory interpretation of 307B, saying that there can't be such a hard and fast rule. We need to, in the discretion, there needs to be that discretion of the board, and you can't just close the gate on fees as a threshold matter. So that was the Lucchino decision. And yes, there was a fee award in that case. So under Solberry and under Lucchino, if you have a fee award, you look at that award for abuse of discretion. There's no fee award here. There's a statutory interpretation at the EHB level, and that was the solitary fact.
In this case, there's a declining of providing a fee award. Somewhat of a fee award by omission. It's still subject to the same review. The question is, was there an abuse of discretion in declining to give the fee award?
Well, Your Honor, I would say that there was one fact that was considered by the Environmental Hearing Board in this case, and that's that we did not allege bad faith.
Yeah, let me back up then, and this is in furtherance, I think, of what Justice Donahue was asking you as we struggle to get our hands around the case. If I understand, I think I understand the catalyst test under Solberry. Here, the Environmental Hearing Board seemed to approve a two-pronged test. I think under Solberry, if the entity from whom fees were sought was a private company, Sunoco, you had the people seeking fees had to prove bad faith. Alternatively, if you were seeking fees, even in the same case, against a public entity, DEP, that then you would use the Solberry, the catalyst test. Is that right?
That is what the Environmental Hearing Board did here, yes.
Is this the first case? I incidentally agree with you. As a matter of due process and equal protection, they can't pool a different standard, notwithstanding the statutory language, where I think I probably agree with Justice Brobson, it's an inappropriate constitutional delegation, but that's not before us today. They can't pull a different standard down for every case and, flip a coin, throw things down the stairs to get their standard. But in terms of the standards that we have here, have they used bad faith before?
Not in this situation, Your Honor.
Well, when have they used bad faith before?
The only instance in which they've used bad faith before is when one is requesting fees as against a third-party appellant, such as my clients. That's the only instance. And, Your Honor...
well, you'd like that.
Well, Your Honor, there's a motivating purpose behind the General Assembly's passage of the Clean Streams Law, and that is to protect and improve the quality of the waters of our Commonwealth.
Can I ask you, though, I don't think there's much contest about the remedial nature, but if we agree with you and reject the EHB's use of a bad faith threshold and say you do get to use your discretion, but this ain't it. You can't do the threshold bad faith thing and send it back. And going forward, I'm just trying to think about whether we are spawning a cottage industry of collateral litigation where your client and similarly situated litigants and the permittees then have to litigate post hoc what the settlement was really about, or what the motivations were for the settlement, or what catalyzed what, and why we agreed to X and why we didn't do Y. So I guess, is there a virtue of finality in whatever discretionary threshold that EHB might adopt, so long as it isn't wholly irrational.
Yeah, I understand your concerns, Your Honor. There would be great finality in saying fees can't be awarded at all, and there would be a certain virtue to that. But I don't see an actual concern here in changing the motivations of the parties, or in having to undergo a deep subjective motivational analysis. And I think it's actually very clear in how the EHB has applied the catalyst test for the last 15 years. Those concerns haven't materialized. Here, I think the case at bar is actually very clear that you wouldn't need to look to those subjective motivations. We have a written settlement agreement. We know what we got. The Environmental Hearing Board knows what we got out of this.
And that settlement agreement, and I don't want to interrupt, but that's between DEP and your clients.
No, Your Honor.
Go ahead.
So, and it's actually two settlement agreements. So one in 2017, one in 2018. And they are tripartite, right? On the one hand, us, on the other hand, DEP, and the last hand, third hand, Sunoco. But if you look at the concessions, who gave what, it's very clear Sunoco is giving up a lot in order to protect the waters of the Commonwealth, which is why we brought these appeals. That's the meat of the case. That's the substance here. If we asked for DEP to have all the burden of paying for Sunoco's concessions, I would argue that is not in line with fundamental fairness here. It should be Sunoco who gave up stuff, who caused the problems in the first place where we needed to have this proceeding, that bears the burden of paying. And under the catalyst.
You have two settlement agreements. Sunoco is a party to both of them.
Yes, Your Honor.
DEP is a party to both of them.
Yes, Your Honor.
And you're a party to both of them.
Yes, Your Honor.
And what you want us to do is to reject bad faith, remand the case, and direct that the catalyst test be employed here to consider your request for fees against Sunoco.
Yes, Your Honor.
Are you seeking fees against DEP?
Your Honor, we settled fees with DEP.
Okay, that's right. I remember that.
Can I just follow? I just want to clarify something because I wasn't sure if there's a variance between the briefs and what you're. Is it your client's position that with whatever test is applied, that the shareholders of these permittees should be treated differently than the taxpayers or not? In response to the Chief's question, I understood you to say they should not be treated differently. Is that still your position?
Yeah, in a case like this, yes, Your Honor, that's right. In a case in which we have DEP and the permittee on the same side of the V, that should be how it goes. There may be differing equities in different cases. I can only speak to the case at bar.
You're just saying, not as a blanket matter, you don't agree with that variance.
Yes, Your Honor, and I would say specifically that the plain language of 307B does not support that, and time and again when this court has analyzed fee-shifting provisions with that plain language, it said you can't throw up new threshold barriers to fee recovery. This is a long line of cases, Bowser versus Blom, Lucchino itself, the Solberry case itself. They've all been saying you can't lock the gates to fee recovery for this new threshold test. It's been consistent.
Counsel, let me just clarify something, because this is what sort of surprised me as I was trying to understand this case. This is the first time that an entity such as yours has sought fee recovery against a permittee?
No, Your Honor. Actually, this is just the first time it's gotten to this court. And that's not even true. In the Solberry Township case, fees were recovered against both the department and the permittee in that case. And there have been other cases in which fees...
Catalyst test.
I'm sorry, Your Honor?
Using the catalyst test.
That was... Yes, that's right, on remand. Yes, Your Honor.
I'm sorry to go back to square one, but I am still lost a little bit here. My understanding, and tell me where I go off the rails with this, is that Sunoco filed for permits, which were granted by the department. Your client was unhappy with the scope of those permits. So you on behalf of your client, filed an action to have the permits changed for safety factors.
In essence, yes, Your Honor.
Okay, and did Sunoco engage in that litigation that you filed with the department to have those permits changed?
Very litigiously so, yes, Your
Okay,
Honor.
so they defended their permits?
Yes.
And as a result, you got changes that you wanted, and then you filed a fee petition against the department, which settled, as well as against Sunoco, which we're here on now.
Very close, Your Honor. So we had settled fees with DEP without filing a fee petition.
Okay,
The fee petition itself was solely against Sunoco.
all right, okay.
You've done a fine job in teeing this up. Unfortunately, we have, I don't know how many more lawyers to hear from. So if you've got us to the point where we at least understand the alphabet, we can begin to build sentences.
Yeah, thank you very much, Your Honor. And I would just say, if I may, you know, this is, what we're asking for is consistent with an unbroken line of this court's precedent, as I mentioned, the Bowser versus Blom case, Lucchino, Solberry. So Your Honor should respectfully remand to the Environmental Hearing Board after reversing the too narrow interpretation of the Clean Streams Law's fee-shifting statute.
Thank you very much.
Thank you very much, Your Honors.
Mr. Raiders, are you next? Who's next? Or are you all done?
They're still going.
And I'm sorry, you are, well, introduce yourself, tell us who you are, and proceed to argue with the respectful admonition to not repeat, which don't undo what we just did. We understand the case.
Good morning, Mr. Chief Justice, Associate Justices. May it please the court, Rich Raiders for the Gerhardts. And I thank the court for their accommodation for my immune issues, so I appreciate the assistance. Your Honors, I'll be discussing specific aspects of 74 MAP 2021, especially our argument about the fee award process in Section 2 of our brief. If you recall, the Gerhardts prevailed on the merits in the hearing that the L24, L25 wetland characterization issue, where the wetland was found to be forested by the board. The Gerhardts have been deeply concerned about the lack of transparency and the accountability in this permitting process, where both the department and Sunoco failed to properly document our little forested wetland on the Gerhardt property. The Gerhardts believe that both the department and Sunoco should be held accountable for their failures and assign liability for this very limited fee award. The court should remand the matter back to the HB and allocate the award between the department and Sunoco. As the Gerhardts prevailed in the wetland characterization issue, the family satisfied the Qualwasser four-part test that was discussed earlier. Once the board found the Gerhardts satisfied Qualwasser, the board moved on to the Hatfield Township test that it had been using for the last decade to determine the amount of the award. The board developed this in its discretion based on the remands and so forth that you discussed concerning the Solberry matter. The Gerhardts are confused why the board and the Commonwealth Court felt any need to develop a separate test to determine fee awards and its allocation when Hatfield Township already takes care of the issues that we're discussing today with a couple of small adjustments. The board identified 10 non-exclusive factors to consider when awarding a fee. The board on several occasions noted that this analysis can be flexible and fact-specific, with slight adjustments to 2 of these factors that we could accommodate the issue of how to assign fees based on the existing Hatfield Township test.
Counsel, can I just see if I have this correct in my mind? The first attorney who argued before us said this is a case where there was no final adjudication, consequently the catalyst test applies.
Yes.
And there's no reason not to apply that same test to permittees that you apply as to the taxpayer paying entity.
Yes.
Correct? You would stand here and say, same thing, except I have a final adjudication, and you should be applying the test that was developed in Qualwasser that is applied when the fees are against the taxpayer entity, and that's the same test should be applied to permittees.
Yes.
Okay.
And further extended by how the board goes through its process. Justice Wecht asked a question a few minutes ago about a cottage industry of litigation about the fee assignment. The EHB already goes through the fee process. They already do a separate order for that, as you've seen. And I don't know if that would generate an additional cottage industry, but it's already a process that they do in minute detail.
And in your case, again, just to make sure that I understand this complicated matter, you're actually a prevailing party.
We prevailed on the merits for our little 2,500 square foot of wetland in the backyard, yes.
And did you prevail against DEP, against Sunoco, or against both?
Both.
Right, or neither? Against
It
both.
was me against 5 other lawyers, yes.
Good job. And when you prevailed, have you settled with DEP?
There's no settlement. The nature of what Judge Labuscus did was he ordered that the wetland that we found that we thought was forested, he ordered that that wetland be treated as forested. He didn't actually have to change the permit because he was able to make the accommodation based on his review and his site visit.
So you had a final order.
I have a final order.
And you're prevailing party. And you mentioned Hatfield, but I can't pull that from my memory now. Is this a Callwasser test because you're a prevailing party?
Yes, the EHB adopts the Hatfield Township test as how it calculates the fee.
Is that different than Callwasser?
It is a supplement to Callwasser. Because once it goes past Callwasser, then it goes in, I need to come up with a number. And then it uses the Hatfield Township to come up with a number based on from Callwasser.
I got it.
Could I follow up on that, sorry, Chief.
Oh, no, but I'm almost done. I may be beating the dead horse, but I just want to make sure I understand the case. So I'm looking at the 4 criteria of Callwasser. Your position is you meet all those, therefore you go to Hatfield to get to a numerical award. Is that right?
Yes, Your Honor.
And they didn't do that.
They did.
They did do that.
And I came up with a number, and EHB is very good at giving third-party appellants a haircut, and they gave me a good one.
So you're here for what? For a remand to tell them?
Remand for assignment, because I'm an appellee in this matter. The department appealed on my case. I was just brought along
The department wants Sunoco
to
pay the
to help.
rest of what's owed to you and to reimburse them for what they paid to you, or are they willing to bear an allocated part of that fee award?
I'll let Mr. Yurkovich speak for himself, but I think what he wants is to allocate the fee.
Okay.
Well,
But he also wants you to
You're
be
an appellee,
I'm an appellee.
so you don't want anything.
My client wants transparency.
You want affirmed.
Well, no, actually, my client, I'm asking for a remand for allocation because, let me go way back into the Wayback Machine here. At the very beginning, there was a settlement offer that Judge Labuscus talks about in his original opinion. And the reason that we didn't settle at that point is because my client wanted everything to be on the record, and a lot of the details of settlements tend to be confidential, and they weren't interested in that because they didn't think that Sunoco would go along with having a public record of the settlement. They thought there might be confidentiality. And they're kind of a little bit of advocates for transparency in the process, which is why they've come along all this way. And Judge Labuscus said in his opinion, yes, we understand that what you're trying to do, but we don't pay for that part of it. We only gave you an award for the part that we thought was advancing what you wanted out of this permit. So I'm getting paid no matter what. It's just a matter of who's going to pay it.
Can I ask you about that haircut? And I don't know if this gets too far into the weeds or the wetlands, I guess. The EHB, they seem to distinguish between the efforts your clients took with respect to their property and then their persistence in seeking a more broad ruling. Isn't that right? And I'm interested in knowing, are you or are you not questioning their discretionary calls in that regard? Where they said, for example, quote, "We do not believe it is a position that the taxpayer should be required to underwrite," unquote, with respect to your client's persistence seeking a broader ruling that all, wetlands should be classified.
A couple of different things there. The first part was my clients do a bit of public advocacy and they're interested in having a transparency and they wanted to push the case all that far. The second issue that you're bringing up is that there was a major question about how to determine whether the wetland was forested or not, especially based on the fact that the trees were gone by the time anybody looked. And the consultants in Smitten Company had a theory that they were pushing in the hearing about overhanging branches versus stumps and trees in the wetland itself. And Judge Labuscus ruled that I didn't have to hear about the overhanging branches theory because there was enough trees and stumps in the wetland itself that none of that mattered to me. I'm not paying for that because you didn't need to raise it because I found for you on the merits based on the stumps themselves.
So you are or are not challenging that exercise of discretion?
We decided back when the fee award came out that we were not challenging that.
That's what I thought. That's what I thought. And that's, I think that's, well, let me just leave it there. Okay.
All you
Well, let me-
want is your entire fee award.
I want my entire fee award, and my client would like to see that Sunoco participate in that fee award.
But, and this is the third question in a sequence among the three, bang, bang, bang. Yeah, and I've been doing this a long time. You're Aplt, you didn't take an appeal. I don't see where you have standing to ask for anything except this matter is affirmed. I don't think in my life as a lawyer and judge, which transcends 50 years, I've ever seen an Aplt seek a remand.
I'm in a very weird position here.
I'm not sure you can do it, but we'll have to unravel this when we're done.
Well, are you saying you are actually
do that?
both an appellee and an appellant?
No.
I'm
I'm trying to help.
I understand that. In a way, we kind of are because we agreed that we were not going to question the amount of the award because the amount of the award is what it is. We're not there. What we disagreed with was that the bad faith test and the allocation we don't agree with, and we didn't choose to file the appeal to this court on that question, but we're here, and so we are impacted by it, so we're definitely a party who has an interest in this matter.
You may end up getting what you want by accident because of other parties who did take appeals and do want remand, so
That is entirely possible.
we'll see how it works out.
Hypothetically, we remand this, you can benefit from their remand.
Yes.
Okay, that's feasible.
Can I, just for clarity, what was the amount of the fee award that you requested?
We requested, what's it, $254,000.
Okay, and DEP paid what portion of that?
The award was $13,300.
So you're out 240 or so $1,000 in fees that you would like to be made whole on?
No, I don't. My client let that water go way past the bridge, so we're not getting
Then I really don't know why you're here. Then I thought your argument was you took a haircut for the benefit of the department. However, Sunoco should pick up the remainder of that fee award.
That's not what we
Okay,
petitioned.
well then I don't know why
Why
you're
don't you,
here at all.
in your conclusion, in one sentence, tell us really precisely why you're here and what you want?
Why we're here is because we believe that the process of not having the party who filed the bad information that the department relied on and got through the process should not be liable for fee awards. When it was the Sunoco applications that were wrong, the department relied on the wrong applications, we prevailed on fee, and then we should have the opportunity to have the people who are responsible for the mistakes in the process pay for the damage that they did, unlike what we have in.
Go ahead, Justice.
So you don't want the 240,000 remainder?
We let that pass. I mean, I'd love to have it, but
What
we
is
let
it
it go.
that you do want, I guess is the question. What are you asking us to do for you?
Send it back to EHB and let them allocate the fee between Sunoco and the department.
What fee?
You're here.
The $13,000 we already have been awarded.
You're here to support DEP.
Yes.
Period. You're amicus.
Well, in a certain sense.
Yeah.
Mr. Riders, your fee was awarded against DEP. You'd like to see that reallocated so Sunoco has to pay part of it.
Yes,
That's what it is.
I do.
This isn't determinative or maybe not even relevant to our decision, but why are you focused on the division of the 13,000 and willing to walk away from 240,000?
My client made a tactical decision that it was okay. So
But and again, we're done, but it's interesting, your client did that, but your client's paying for you to be here today, so your client's a saint.
I do have one other quick thing I'd like to mention quickly, if you mind a second. In Sunoco's brief, they did talk about a couple of EHB decisions, Jay Township and Harmer, and there's some distinctions that I think that I'd like to call the court's attention to, and that those two cases were where the board refused to award fee to a third party because the department failed to ask for information that it should have asked for, and thought that the department was negligent in asking for, in one case, acid mine drainage information, in the other case, groundwater information. And we think that those are easily distinguishable here because in this case, the department didn't fail to ask for wetlands characterization sheets. The wetlands characterization sheets were just wrong. Thank you.
Thank
We
you
did
for your
not,
time.
just one more thing, we did not actually grant review to assess the formula that led to the calculation you're talking about. So I'm not, I don't want to reopen the whole can of worms, so to speak, or get into the weeds of that marshland, but we did not grant review on that formulaic calculation.
You're not challenging it though either, are you?
No,
You're
I do not.
perfectly happy with the Hatfield calculation.
I'm happy with the calculation. I have my client decided to take that decision that it's okay.
He's sort of representing DEP a little bit. Thank you very much, we got it. Mr. Jurgovich, and you represent DEP?
May it please the court, it's George Yugovich, and I'm with the Office of General Counsel, representing the Department of Environmental Protection.
And just again, before you begin, so that we understand the players and the game, I guess, are you here to oppose something, to urge for something? What brings you, or you had nothing better to do today?
We're here because the Environmental Hearing Board established a rule that's not in the text of the legislation that removes a party that would otherwise be potentially responsible to share fees whenever we make a mistake issuing a permit.
So therefore, you would be aligned to some extent with Mr. Raiders, who would like to see some of the 13,000 shifted from you to Sunoco.
We are aligned with both Mr. Raiders and the Clean Air Council on that legal issue.
Clean Air Council just wants fees, and like you, they want to get rid of the bad faith test, go back to the catalyst test. Under the catalyst, get on a remand, get fees. And you are an appellant. You did take an appeal.
Yes, Your Honor.
Okay, go right ahead. I hope that's helpful.
What I'd like to focus the court's attention on is the issue of statutory interpretation. That's why we're here, right? What the Environmental Hearing Board did was take a section of the statute, 307B, which grants them discretion to award fees, and develop a standard that doesn't exist in that statutory provision. A standard.
It doesn't say, though, Counsel, it doesn't say that they don't have discretion to adopt a standard. And arguably, the fact that the General Assembly hasn't stepped in and said adopt, prevailing party or adopt this standard, doesn't that also suggest they're saying EHB, use your discretion, meaning that we would review on an abuse of discretion standard, which just circles back then to the question of why adoption by them of these thresholds would be an abuse.
That's inconsistent with this court's precedent. Just recently, in the in re November 3rd, 2020 general election case, this court held that it's not appropriate for courts to imply a requirement in a statute that was not made express by the General Assembly, where there's facts to show that the General Assembly knows how to express its intention explicitly. And that exists in this case.
Isn't what you're asking for today directly contrary to this court's holding in Salisbury?
It is not, Your Honor.
In Salisbury, it says the EHB may, in its discretion, award attorney's fees under Section 307 solely on the basis of a finding of bad faith or vexatious conduct which is supported by the record without reference to the Kohlwasser criteria.
So I believe that statement in Solberry refers back to Lucchino, and what the court did in Lucchino was assess whether, under the largely sui generis facts of that case, where someone actually took an appeal and admittedly abused the process in front of the Environmental Hearing Board, and a fee was awarded. And then this court said, yes, under those circumstances where a fee was actually awarded, the EHB did not abuse their discretion. So there's a two-step process here that's going on.
I could just clarify, because
I'm sorry, Your Honor.
I think Lucchino is really critical to distinguish, if it's in fact distinguishable, and I'm sure we'll hear to the contrary. But Lucchino stood for the proposition that a finding of bad faith will always be available as a basis to award attorney's fees. It did not say that the absence of bad faith means that you can't award attorney's fees. Am I correct?
I agree with that assessment, Your Honor. Absolutely.
Just to back up, though, as a follow-up to my question, but the facts in Salisbury weren't the Lucchino facts where the court made that finding.
That's correct, Your Honor.
The facts in Salisbury are closely similar to what we have before us today.
Except that the Environmental Hearing Board in that case did not interpret the statute in a way that precludes an entire set of responsible parties that the General Assembly said should be considered responsible parties, and that they are not. Now the Environmental Hearing Board's decision removed them and said they're not potentially responsible parties unless they engage in bad faith, and that's why we're here.
Counsel, can I just follow up on your opening statement before this line of questioning? You said that what the Environmental Hearing Board did here is adopted a test based on language that is not in the statute. I might point out to you that neither is the catalyst test.
That's correct, Your Honor.
Neither is Kohlwasser.
That's correct, Your Honor.
So, I mean, it can't be the text of the statute that drives the determination of this issue, because the text of the statute says in its discretion.
I would disagree, Your Honor. I think the text of the statute has to be determinative. What is the difference is how you perceive what is exercise of discretion, right? There's establishing a legal standard, which the legislature demonstrated it knows how to do when it wants to, when you look at the mining legislation that we set forth in our brief, versus exercise of discretion. And the Gerhardt facts, the facts of that case, I think are a perfect example of what why the board did not exercise its discretion in this case. They short-circuited the process, right?
Yeah, but that you're sort of circling back to the issue that there is a standard that's been developed.
Yes, Your Honor.
But
there's criteria.
Where in the statute does it require the Environmental Hearing Board to even develop a standard? Back to the Lucchino case. They said that.
Well, I mean, the standard is abuse of discretion, right? Whenever the board exercises discretion, so they have to justify their award of fees, both the amount of the fees and allocation to the responsible parties based on the facts.
It has to be in other words, you're saying that the textual language, discretion, must imply a reasoned exercise of discretion and that the categorical threshold is ipso facto not a reasoned exercise of discretion. But again, circling back, is it necessarily unreasonable for the board here to say, in our discretion, we find it reasonable to impose this threshold, presumably in part in order to avoid serial litigation post hoc over who won, who catalyzed, and in response to some things that Sunoco is talking about here, like which permit you won here, you won halfway, you won a quarter of the way, et cetera, et cetera.
If I understand Your Honor's question, Justice Weck, yes, I believe that would be unreasonable. I don't think it would be reasonable for the board to avoid its obligation that's given to it by the legislature to exercise its discretion simply because it's going to require more work for them.
But it doesn't. I mean, they already do that. They do it.
That's correct.
They do it when fees are involved against the department. I mean, but suppose they said, it's our determination that in our discretion, we believe that it's inappropriate to tax an industry that's adding to the economic development of the Commonwealth of Pennsylvania. Is that unreasonable?
Yes.
And why is that?
Because the legislature has demonstrated that they can set those standards and will set those standards. And the legislature chose not to do that in this case. So the lens is to look through this decision is who makes the decision? Is it the General Assembly or the Environmental Hearing Board?
This gets back to the question I asked like 7 or 8 hours ago, which is, was Sunoco a party? Because the statute is directed toward awarding fees against a party. So if the legislature wanted to exclude one such party, i.e. permittees, they clearly could have done so, but they did not. Am I understanding that?
Yes, Your Honor, and in our brief, we and Judge Renwan, in dissent in front of the Environmental Hearing Board, made that point, right? He cited to the mining statute, and in the mining statute, the legislature not only distinguished between the different parties before the board in exactly this type of hearing, only, instead of a clean water case, it was a mining case. The legislature distinguished between permittees, between the department, and between third parties. And they set different standards for when each party would be liable for fees. And what's particularly interesting about comparing the board's decision with what the General Assembly did in the mining statute is, in the mining statute, the General Assembly attached the bad faith standard to the department and third parties. So the General Assembly expressed a policy by which it said in the mining provision, the General Assembly said, our preference is permittees, where fees are awarded, permittees are the ones that should bear the brunt of paying those fees. And the department doesn't pay the fees and third parties don't pay the fees unless they engage in bad faith conduct. That's why the Environmental Hearing Board should not be making these decisions, right? That's what the General Assembly is supposed to be doing.
Except you can't get any of that from the statute. As Justice Donahue said to you, and I'm reading the statute, I know you have it emblazoned on your heart. And then all it says is the HB, upon request from any party managed discretion, order the payment of fees. That's all it says. I think, I know I agree with you that as a matter of fundamental fairness under due process, this can't be applied willy-nilly. So there has to be tests. So unless we invalidate the statute as an inappropriate delegation, which is from the legislature to the board, which is not before us today, then it seems to me that we or the judiciary has to come up with tests and then apply them consistently.
Well, this court already has, right? So is Commonwealth Court, so is the Environmental Hearing Board. The test is abuse of discretion. Once the Environmental Hearing Board finds facts
let me stop you. They found that fees should not be awarded against Sunoco. Is your burden here today to show us that that's abusive of their discretion?
No, Your Honor. Our burden is to show that it's an unlawful interpretation of the statute.
All the statute says is in their discretion.
So,
if
Your
it's
Honor,
not abuse of their discretion, how can it be unlawful under that statement?
well, let's consider that question in the context of the facts of the Gerhardt case, right? The reason the Gerhardts...
Well, then what you're arguing, I want to make sure I understand this, because otherwise it does no good. you're going to go to the facts of Gerhardt, but what you're arguing in substance is that under the facts of Gerhardt, the EHB's awarding of fees against your client alone is an abuse of discretion. Because if that's the statutory test, that's what you have to overcome, which is where I think you're driving your train.
So in Gerhardt, the only thing the Environmental Hearing Board found improper about the permits that my client issued was that Sunoco had mischaracterized the wetland. And as a result, after they disturbed the wetland, they had to go back and restore it a certain way because it was a different kind of wetland, in fact, than how they characterized it in their permit application. So in fact, the department, nothing about our permit was found to be incorrect, except for this that we agreed with this mischaracterization of the wetland, which only affected how it would be repaired, okay? So what the Environmental Hearing Board found was Sunoco had submitted incorrect data about the wetland to the department. They applied for the permit to disturb the wetland, and the board actually found the department reasonably relied on Sunoco's mischaracterization because when our inspectors went out to look at the wetland, all the trees were already cut down in that wetland. And so that's why we didn't know the mischaracterization was wrong. So the board said, you, department, reasonably relied on Sunoco's characterization of that wetland, and yet we're going to make you pay all the fees. Why? Not because of those facts. It didn't base its allocation of fees on the facts of the case. It based them on one fact, and that one fact was they didn't engage in bad faith behavior.
Again,
and that's the difference.
I don't want to be a dog with a bone, but what I think your argument to us is under these facts, what the EHB did was abusive of its discretion, and therefore violative of the statute.
Your Honor, I apologize, but to disagree on a fine point, what we are saying is the EHB never exercised its discretion.
He's making the point about the categorical threshold standard.
Yes, Your Honor.
So you're saying they never exercised?
Yeah, because they never got to those facts. If they would have got to those facts, they shouldn't have assessed the fines on us, is our point.
I got it. All right. I got this distinction. Thank you. Okay, thank you. Is there anything you want to add?
I have a lot of other things here, Your Honor, but I think you understand the case, and most of it's in our brief. So I appreciate the opportunity to be before you and argue our case.
I have one more question. I asked this at the beginning of the argument, and just to reiterate, I am just a little confused because I'm looking from the concurring opinion that was filed in the Commonwealth Court by then Judge Brobson, now a justice on our court, and he says, Sunoco was not a party to the settlement agreement between objectors and DEP and essentially ended objectors' appeals. Moreover, Sunoco gave up nothing in the settlement or otherwise. Sunoco kept its permits unaltered as if the objectors had not even filed their appeals with the EHB. Do you agree with that?
I think, Your Honor, the department's position would be that the settlement resulted in improvements to permitting and implementation moving forward. I mean, it definitely changed how protocols that we engaged in issuing permits.
But what we heard earlier, apropos of that statement read by Justice
Was that
Monday.
Sunoco vigorously defended these.
Right, and they were active participants in the process and in the litigation. You
That's
agree with
correct,
all
Your
that?
Honor.
That's fair?
Yes, Your Honor.
Okay, thank you.
Confusion, I can do it very quickly. I was going to start by saying good morning. It's almost good afternoon, but I'll try to do this quickly. Here's what happened in the case. 20 permits were issued by the department. The day they were issued, the Clean Air Council filed an appeal and a supersedious, not to change the permits. They wanted to stop the permits. They said that they were improperly issued. There was a supersedious hearing that took place. It was a 3-day trial, and Sunoco prevailed, and they began operating the construction under those permits. Several months later, the Clean Air Council filed a supersedious petition again, saying the way the construction was proceeding was causing some harm. They were granted a temporary supersedious for 2 weeks. There was no decision on the merits of that at all. Sunoco, the department, and the Clean Air Council entered into a stipulation to settle the supersedious. We can debate, and I'll get to this later, we can debate why Sunoco settled on that basis and what they gave up, but that's what happened. Months later, they filed another supersedious saying, you know, the changes to the plans and the protocols need to be revised again. No finding on that supersedious. That was settled as well. Getting ready to try, a year later, getting ready to try, 4 days before the trial occurs, they settled with the department only. Sunoco was not a party to that. It dismissed the appeal in its entirety. As part of their settlement, they got $25,000 worth of attorney's fees from the department. The department expressly states in the settlement agreement that nothing changed the permits. That's an express term in the document. They could have asked for more in attorney's fees from the department in their settlement. They made a conscious choice in that settlement to say, we want something we can't get in the litigation. And what they got were changes to future department policies. That's the facts.
Counsel, could you go back? Because
Sure.
as I understand it, the Clean Air Council is not seeking fees against your client as to that last settlement that you're talking about.
That is correct.
Go back to your first recitation of what happened after the supersedious was granted for a 2-week period. At that juncture, your client did something.
The
correct?
department, yes, they did. The department.
Something affirmative in the context of the environmental issues involved with that supersedious.
That is correct.
That's what they want attorneys.
That's what they want their attorney's
Period.
fees for.
Okay.
That's
so
it.
I understand that.
Yes.
Okay.
Okay, so that's the facts.
But Counsel, let me
yeah.
jump in with a question here. Even supposing you're correct about this particular instance, that in and of itself wouldn't compel acceptance by us of a categorical bad faith test. So, can you, among whatever else you're going to relate to the argument that a categorical test is by definition not a reasoned employment of discretion?
I think it is a reasoned employment of discretion.
Well, how can it be when there are any number of fact patterns under the sun and the equities run all over the place? How can a blanket rule constitute a reasoned exercise of discretion?
Because that's what the opinions of this court say. So when you look at Section 307B, and I think you've all noted that, the language is clear. This is not a statutory interpretation case. The language is clear. It says that they may in their discretion. The discretion was granted. The question is, in establishing a categorical standard, whether there's an abuse of discretion. Now let's look at what this court has done. The Solberry line of cases say when you settle with the department, it's the catalyst test. That's a categorical test. Every case that involves fee claims against the department, when there is a settlement, they apply the catalyst test.
That's not a categorical test. Let me just, and I'm sorry for interrupting, that is not a category. It's the antithesis of the categorical test because that test requires looking at the facts and precisely what happened and what was the outcome.
Right.
So
It's the standard that is used, and then they have to apply the standard on the facts of that case.
Standard.
Right, and that's it's a standard. And in fact, this court has said in both Solberry and Lucchino that the discretion under 307B is both to establish a standard and to apply it.
Well,
They said that twice.
I'm not necessarily interested in validating past decisions if they're wrong. I may differ with colleagues on that, but I digging underneath. First of all, I mean, when the legislature has wanted to mandate a bad faith standard, they know how to do that. They didn't do that here, they've done it elsewhere. And also, I am interested in you responding to something I asked opposing counsel of why the shareholders are treated better than the taxpayers.
Okay.
I'm
going to answer
I'd like
both
to
of
give me
those.
a reasoned answer to that.
Sure, I'm going to answer both of those. Okay, so I'll do it in reverse order. Let's say why there's a different standards. And you heard nothing from the other side about the actual primary rationale for having a different standard as expressed by the EHB and the Commonwealth Court. And the reason is the difference in position between a permittee and the department in an EHB proceeding. And it's straight from Section 307B, and it's from Section 4 of the EHB Act, because the only thing that you have to review in an EHB permit appeal is whether the department's decision was correct. You don't review the application, you don't review the merits of the application. The exact language in 307B says, the rights of an interest party to an appeal is defined as anybody, quote, affected by action of the department. Not the action of the permittee, but the action of the department. The jurisdiction of the EHB, under Section 4 of the EHB, the board, quote, has the power and duty to hold hearings and issue adjudications on orders, permits, licenses, or decisions of the department.
Okay, let me ask you this, because this gets back to that long ago question. When your client was sued, made a party, why didn't you move to dismiss? We don't have any role in this proceeding. It's only the department's issuance of the permit that's at play. At that juncture, move to dismiss, somebody says, you're right. This only has to do with the department.
We don't have a choice. The EHB rules make us an involuntary party.
And why is that?
I think the reason they made us involuntary is because many cases the permittees were intervening, and they wanted to skip that step as a procedural process to make it so that they don't have to intervene and have a separate motion to intervene.
Does it have anything to do with the fact that the permittee supplies information to the department that they use in the issuance of the permit?
Absolutely, there's no doubt. We have an obligation as a permittee to submit accurate information. We have to certify to that, have an engineering seal. But the decision that is made by the EHB is the department's decision. And in fact,
supply the information, just to follow up on Justice Donohue's question, I mean, certainly correct, they're the decision maker, but it begs the question, upon what is that premised? So in Gerhard, for example, I thought the permit was, or at least some aspect of this, was premised on an erroneous designation that relied on information Sunoco provided. So why is the fact finder not entitled to look beneath to see that?
well, actually, it's de novo review. You're not limited to what we put in the application. Review in the EHB is de novo. The department can put on additional expert testimony, they can put on additional fact testimony, so can the permittee, so can the other side. And that's because the ultimate decision is, did the department get it right? It's not limited to the application in any way. The application is part of it, but it's de novo review.
Okay, but if the fault with the issued permit has nothing to do with the information that was provided by the permittee, then there wouldn't be a circumstance under the catalyst test or the other test when you have an adjudication where the permittee would be on the hook for attorney's fees.
I don't understand the question, I'm sorry.
It's not a question, it's a statement. I mean, if the permittee had nothing to do with the fault in issuing a bad permit, the permittee had nothing to do with that, then there would be no ability under these tests to assess attorney's fees against the permittee. It's only the situation that we have before us, and I guess Gerhardt is probably the cleanest case, where you have a finding that the permit was bad because of the information that was provided by the permittee, that this issue sort of looms.
Right.
Is that not the case?
I would differ a little bit about what the board said and what the facts were in Gerhardt. So let me just spend 1 second on that.
That's not really,
No, but it's important.
for our purposes, I don't think we're going to decide that factual issue, but
But I don't think the issue was that was just a mistake by the permittee. This is a judgment call as to whether you call something forested or not forested. That's what Sunoco put in their application. The Army Corps of Engineers was at the site. They agreed. DEP was at the site. They agreed. Okay? When it got in front of the Environmental Hearing Board, it was a battle of experts, and the board said, we agree with the expert for the other side. So that was not just an error that the permittee made. I want to go back to the standard setting. So there was
Can I
a
stop you
standard. Yes.
Before you do that, and again, I apologize that out of sequence to some extent, but I'm actually back before the series of questions from my colleagues. Your opposing counsel said without any doubt that you were a signatory on 2 settlement agreements. You dispute that?
No.
Okay. So you did settle something. Accordingly, you had something at stake.
Yes.
Okay. Are they entitled, in theory, to fees against you, putting aside what test to use or how to calculate the who prevails on the fee petition and what they amount? Are they under whatever it is, 307B, entitled to fees against you?
So it does depend on what
Potentially.
test. Potentially, depending on what test you apply. But I will say, and I think Justice Weck said this, there's many reasons people settle. We had a 300-mile pipeline to construct. We wanted to get on with the construction. I think if you ask my client, they would say much of what we gave in that settlement was the sleeves off of our vest. We were ready to do it anyway, and we wanted to get on with the construction.
And I accept that, and I appreciate the indulgence. I think that puts in context
Right.
where we are here.
Right. So I just want to circle back on one thing about the Surface Mining Act, and they had those standards in there so the legislature knows what to do. And then I want to go back to the beginning, if you don't mind, because there is one point that I want to make that I think is critical here. So the circumstances under the Surface Mining Act having those specific provisions in it with specific standards was completely different. The very first sentence of that section, which was passed in 2008, says, the purpose of this section is to provide costs and fees to the same extent as the federal Surface Mining and Reclamation Act. So this was done for a very specific purpose to align the two. There's no analog to the Clean Streams Law, which was passed 28 years before, and the legislature was express in how they wanted fees to be determined under that statute in the discretion of the EHB. I also think this is a really important point, and it's a very important practical point, and I don't think this came through in all the other argument here, and that is that this is not a case in any way, shape, or form where there's been any adverse impact on their ability to recover fees at all. In the Gerhardt case, the Environmental Hearing Board said, we've looked at everything, the total amount of fees are $13,000. They've been paid. In the Clean Air Council case, the Clean Air Council decided that they wanted to settle for $25,000 with the department, not with us, for other reasons, to get other things in their settlement. They got fees. They made that as a conscious choice. Nothing in these cases affects the fact that they were not limited in their ability at all to recover all their fees against the department. Nothing.
They recovered the $25,000 on one of multiple settlements or one of multiple pieces of
They
litigation.
settled all of their fee claims against the department because don't forget, the departments were parties to those settlements as well, all three. The department was the party to all three. They made a conscious choice. They had $200,000 worth of fees. We'll take 25 because we want to get something else. So nothing in this case limited them.
You're not arguing there's some sort of general release that...
No, not at all. What I'm saying is nothing in the opinion of the EHB stopped them in this case or any future case from recovering all of their fees from the department.
that's
The
the crux.
Right, that's it.
That's the crux of, I think, the maybe policy issue, for lack of a better word, but why should the DEP, otherwise known as the taxpayers, bear the cost of those attorney's fees to the exclusion of the permittee?
Okay, so it's not to the exclusion, because there is a standard, there's a bad faith standard. If a permittee submitted an application in bad faith or conducted the litigation in bad faith, tried to be harassing or unduly burdensome, they could get fees against them. So it's not like Solberry. Solberry was a case, and this is really important. Solberry was a case where the holding was, EHB, you cannot eliminate the right to recover fees. Because what they said is, nobody who settles can recover fees, because we're going to engraft from federal statutes the prevailing party standard. That's not what happened here.
Let me modify my question.
Yeah.
Why should the standard applied when fees are sought against the taxpayer entity, why should that standard be different than and much more lenient than the standard to be applied against a permittee?
The primary reason is because the only jurisdiction that the EHB has in their cases is to review the actions of the department. They're not reviewing the actions of the permittee.
So in deciding this case, you're saying that we can't look at the underlying economic reality. So while that permit has been granted, the benefit runs to your client. I mean, they're not doing this out of the goodness. I mean, they're doing this, to, God bless them, to, run a business. So the pipeline is running, and even absent bad faith, why does it disserve, I guess, justice, to allow for fee responsibility in your client? Again, given the economic realities,
Yeah.
and particularly given the taxpayers being on the hook with respect to the DEP.
Okay, so let's talk about the economic realities. First of all, the money does not come out of the taxpayers. It comes out of the Clean Water Fund, which is paid for by penalties for people who violate the statutes. So it's not a taxpayer problem.
Dollar for dollar.
That's how it comes out.
But if it's not used to pay attorney's fees, it would be used for other environmental protection.
Could be, that's correct. But let me give you an idea of the economic realities of this, just so we understand the practicalities of this. The provision in 307 was adopted in 1980. It's 42 years. The court can take judicial notice of this. In 42 years, there have been 8 awards of attorney's fees against the department. The total amount of those awards is $1 million. Half of that was in one case. And in the last 8 years, there have been $30,000 awarded in fees against the department. So when we talk about the policy and the taxpayer, it's not coming out of taxpayer money. And I'll give credit to the department. They do their job. When they get an application, they review it. They make sure that the permit is properly issued. In this case, in the Clean Air Council case, 29,000 public comments, 20,000 person hours in reviewing that.
Mr. Fox, can I bring you back to
Sure.
what I think is central here? The Environmental Hearing Board, if I understand it, looks at the Callwasser test, looks at the catalyst test under Solberry, which may or may not be applicable depending upon whether we have a prevailing party, and then says, well, as to the private permittee, Sunoco, rather than apply those 2 tests, we're going to apply a bad faith test.
That's correct.
Is this the first time that's occurred, or is there precedent for that?
I think in any of the appellate courts, this is the first time that that's happened.
Okay.
And I think the review is an abuse of discretion review, and they did not abuse their discretion. They followed the Clean Streams Law, the EHB Act, and they had many policy reasons for applying a different standard to different parties, which, by the way, this court has done over and over.
Would you agree? I want to try to keep focused because
Yeah.
we're almost done. We've been here a long time. you would agree with me that they can't just pick from, as a matter of due process, I think, they can't pick from the air a different test for every case as their members change and as they slept well or didn't sleep well the night before.
That's correct. They have to have
some
standards.
consistency. They have to have some consistency.
That's correct.
Okay. So, we've worked hard to give them Colwasser, we've worked hard to give them Solberry. Now here they pick bad faith. Perhaps they have the right to do that, but then wouldn't you expect that if next week Exxon is there, private permittee, doing whatever they're doing, that when we're done with this case, that if we affirm, which is what you want us to do,
Yes.
that the test would be bad faith?
Absolutely.
Okay.
And that's what's happened in the past. Because any case that comes up where there's a settlement, the standard against the department is catalyst. Any case where it's adjudicated, the standard is Qualwasser. Any case against an appellant who challenges a permit is bad faith. And now,
I thought you just said to me that this is the first time bad faith.
against a permittee.
So under what circumstances was a bad faith used by EHB prior to this case?
Actually, it's Lucchino, and Lucchino said that it was bad faith when a challenger to the permit acts. So you basically have 4 different tests.
Okay, can I go back to your answer to a question I previously asked? I asked, why should the standard for the award of attorney's fees be much more stringent when there's a permittee as the payor than it is when it's the DEP? And you said it's because the Environmental Hearing Board only has jurisdiction to determine the lawfulness of the action of the department.
That's correct.
Okay. Why aren't you standing here saying that there is no authority to award any attorney's fees ever against a permittee if that's the rationale for a reduced standard?
Because that would violate Solberry. Because if you eliminated the ability to recover fees against a party under any circumstances, that's what Solberry prohibited.
But
Here they established a standard.
I thought what Salisbury said is you can't eliminate the opportunity to collect an attorney's fee. Your argument is these people got their attorney's fees. So back to my question, if the rationale for this lessened standard to be applied to permittees is that the department doesn't have they only have jurisdiction to assess the lawfulness of the activities of the department, your logical argument would then be there's no authority to assess attorney's fees, period, against my client. They're only here to determine whether or not the department's conduct was lawful.
Right, but there are instances, and we had this exact discussion in the oral argument in front of the EHB, there are instances where a permittee could act in bad faith and have fees awarded against them. So let's assume they submitted a fraudulent application, not just a mistaken.
It's the flip side of Lucchino.
Yeah, it's the flip side of Lucchino. It's exactly the same thing as in Lucchino. Or in the litigation, they started harassing the other side or made misstatements to the board.
Mr.
That's
Foster,
bad faith.
And this is, Justice Donohue was following on what I asked, and I'm still in sort of the same position, although I think this may do it for me. Your client, and again, as Justice Weck said to you, God bless them. They provide a valuable service. But they make billions of dollars each year. This is part of doing business. What is the public policy or rationale behind giving them somewhat of a pass from paying counsel fees that concern citizens when they do something wrong but in good faith?
So I guess the public policy is that's not within the jurisdiction of the board to make the determination that we want a private party to pay because the DEP made a mistake in their permit.
Although I thought,
decision.
and I thought you just had this conversation with Justice Donohue, and I thought I understood it. To some extent, when they find a lack of bad faith, they are in fact adjudicating your responsibility. They're not saying, we don't have jurisdiction to do this, you're dismissed. They're saying, you're prevailing because you weren't in bad faith. So they are judging you.
They are.
Just like the result.
With a different standard.
Well, the same standard, but the flip side of the coin.
Yes, that's correct.
So I don't, again, last question, I promise. That seems to me inconsistent with the argument that they lack the authority to award fees against you. They have the authority, they choose to use a bad faith standard, and they choose to find no bad faith.
I agree with that. I'm not saying they lack the authority. The 307B gives them the discretion, and it gives them the discretion to set a standard, and they've set a standard, and they base that standard on the statutes and public policy reasons, and the only way that that can be overturned is if they abuse their discretion, and you can't substitute the judgment for them. They went through 8 different tests to look at what the right standard was, and this is how they exercise their discretion.
What's the public policy reason? And it's not that they only have jurisdiction to determine the lawfulness of the department. That's statutorily based in your view. What's the public policy?
So there were a couple that the board focused on. Number one is a permittee should have no less right to be able to defend their permit than a third party should have to challenge it. That was one public policy that they came up with. Second one is how they allocate their own resources, the EHB. They described what would happen if you applied the catalyst test to both the department and to a permittee. You would then have to have a mini hearing to determine why the parties settled, what was the basis of that, what was the relative fault between the two parties. You heard Mr. Rader said what he wants is to go back and have the Environmental Hearing Board figure out the relative fault between the parties in the application or the decision to grant the permit. What the board said was that would be a protracted, backward-looking process that would not be in the public interest, nor would it be a wise use of the board's resources. So that was the second policy. The third policy reason is they said it would inhibit settlements, which is a widely held public policy that we favor in this Commonwealth. And they said if you have a standard that is going to be more liberal in awarding fees against a permittee, they're not going to settle because their settlement would expose them to fee liability. Those were the 3 public policy reasons that the board expressed and the Commonwealth Court accepted as a reasonable exercise of their discretion.
But doesn't our case law establish that fee-shifting statutes need to be liberally construed?
It does, and I'll give you the exact quote in Solberry because it makes the first point that I made as to what this is all about. Solberry says that the policy behind Section 307 is, quote, to compensate parties who challenge agency action. Agency action, not the permittee, the agency's action. That's the public policy of 307B. And as I said, as a practical matter, they've been paid. And nothing stops them in the future from recovering all of their fees from the department. Nothing in a bad faith standard against a permittee stops that.
My understanding was in Salisbury on remand, fees were awarded against the permittee.
I'm glad you brought that up. So if you look at footnote 3 of the remand in Solberry, what the court said was, because it was sister agencies, it was the department and it was the Department of Transportation. They did not argue that they weren't sister agencies, and in footnote 3 it says, they assumed that they would be jointly and severally liable, so we're just going to accept that assumption. They made no finding as to how to allocate the fees or whether even DOT was responsible, because the parties just said we're sister agencies, we're all part of the Commonwealth, and so there was no finding in the remand on Solberry that DOT had to pay. They just made an assumption, and that's right in the footnote on the remand.
Good? Justice Webb? All right, Mr. Fox, thank you very much. I think we understand this case. We understand your position.
Thank you.
Have a good day.
I don't believe you introduced your co-counsel to us.
I don't have a co-counsel.
What's he doing?
I was teamed up against here. It was three on one.
You're the Lone Ranger.
You did just
I
fine.
was, thanks.
Thank you.
Thank you.
I'd like
Additional case.
Yeah, yeah.
In this matter, the Pennsylvania State Police appeal from a decision of Commonwealth Court that reversed the state police's determination that Apelt was subject to lifetime reporting under the Sexual Offense and Registration Notification Act, which is known as SORNA. State police had determined in their proceeding that the crime committed by the Apelt in accord with the Uniform Code of Military Justice was comparable to a crime in the Pennsylvania Crimes Code, which resulted in the Apelt being a Tier 3 offender under SORNA, which requires lifetime registration. Commonwealth Court reversed. They found the two offenses were not comparable because the mens rea required for the military offense was broader than the mens rea required for the Crimes Code offense. State police argued that that was error, that the Commonwealth Court applied a higher standard of requiring two provisions to be equivalent when the statute says comparable. So if that does it, Mr. Portman, feel free to proceed.
Good morning. Thank you, Your Honor. Thank you, Chief Justice Baer and Associate Justices. Stephen Kip Portman. I'm an assistant counsel to the Pennsylvania State Police. And I am proud to be here today arguing on behalf of the Pennsylvania State Police. The approach used by the Pennsylvania State Police appropriately accounts for the fact that registration under revised subchapter H, or under SORNA as the Chief Justice identified it, is a civil matter and effectuates the legislative intent of the statute. That process is to apply the plain language of the statute and review all relevant evidence, including the elements of the crimes and any other evidence that the PSP is able to obtain, to determine which offense, if any, under section 9799.14b, c, or d, is comparable to the sexual offender's military offense as required by section 9799.14b21, c17, and d13.
Could I ask you, counsel, how could, we're talking about the criminal law.
We are,
right?
Your Honor.
So how can statutes with different mens rea be comparable? I mean, comparable in the sense they can be compared, but not comparable in the sense that they're the same.
Our position, Your Honor, is that all of the elements are relevant and that a determination should not just rest on whether mens rea is equivalent or identical.
Let me ask it in a more detailed way then. Under the federal statute, one could be convicted under a negligence standard, know or reasonably should know. Under the Pennsylvania statute, at the very least, recklessness would be required. Given that reality, how could the law allow for a judgment of comparability between them, a person having been subject to conviction under the one in circumstances that would not support a conviction under the other?
Well, we're not talking about convictions here. We're not talking about a sentencing scheme. This is a civil scheme in which a person is to register based on a conviction. If this court affirms the Commonwealth Court, and the only thing the Pennsylvania State Police has to look at is mens rea, well, we deal with criminal offenses from the other 49 states, the federal criminal code, and other countries. I can't stand before you and say that we won't have an issue with mens rea in every case, as there will be issues with the other elements of every case. He was convicted of non-consensual intercourse with a woman who was too intoxicated to consent.
But if it's premised on sort of spitballing it, like saying, here's the kind of episode it was a, quote, sex assault, unquote, that just means that in every single case, we're gonna, I guess, would have testimony, from a trooper here, there was a sergeant who gave opinion testimony about what the statute means, which is peculiar, but if it just ends up being sort of a rough estimate of the kind of episode it is, isn't that in derogation of of our duty to interpret the comparable analysis for statutory purposes. In other words, doesn't it have to be categorical? Don't we have to lay the statutes next to each other and compare them rather than lay the episodes, the facts of the episodes next to each other?
Well, Your Honor, if we were dealing with a criminal procedure situation, I would agree with you. The categorical approach is used on the federal side for sentencing to determine whether or not it's a predicate offense for purposes of the Armed Career Criminal Act, or it may possibly with a deprivation of a constitutional right, such as a application to possess, application to carry.
Although, go right ahead. No. Justice Mundy, please.
Thank you. My concern is, unless we have some type of analytical framework that is employed to determine whether these statutes are comparable, where does that leave our courts and our citizens to have any understanding as to what is the expectation when they find themselves in this type of scenario?
Well, I submit, Justice Mundy, an individual convicted of sexual assault through military court-martial is going to know that when they come into Pennsylvania, sexual assault 3124.1 prescribes the same conduct.
But that's not, let me try. And I think it's the same thing Justice Wecht asked you, but much more concretely.
Yes.
With all respect, I appreciate that you're trying to keep Pennsylvania safe. In the military scenario, the airman testifies, and this is hypothetical, we don't know what he testified, that they were out partying, that they were having a wonderful time, that she goes back to his room with him, that they begin foreplay or whatnot, and that he thought this was consensual. She testifies, well, I had too much to drink, and during foreplay, I lost consciousness, and it was not consensual. She prevails. You take that to the district attorney of Dauphin County, and he says, look, that's a negligence on his part. He thought he was engaged in a mutually willing relationship. She wasn't. She won that credibility in the military. I'm not bringing that prosecution in Pennsylvania because our statute says intentionally or reckless. So on that basis, the one prosecutes and prevails, the other won't even prosecute. And so even though it's a civil collateral consequence, it's between 15 years and a lifetime. Why isn't that a false equivalency? Just because of the nuances of the mens rea, which was said to you.
It is the nuances of the mens rea, and it is prosecutorial discretion. Prosecutors don't have to bring any case if they don't want to. But in this case, AL was the Court of Military Appeals, found AL acted intentionally, based on the record.
They said they had adequate evidence.
Right, and based on the record before them.
That's like us reading a cold record and making a statement that is a conclusion, but a conclusion that was not made by the fact finder. The fact finder here just sort of read the statute into the record. You'd have a different case entirely. As the Commonwealth Court recognized, if you had a record below that indicated that he intentionally and knowingly assaulted this woman who was incapable of consenting. But that's not what the record below said.
No. Yeah. I appreciate that we're probing hard. We do understand your position. Why don't you take a minute or two, and we'll let you speak and give us your best shot, and then we'll hear from the other side.
I submit that if you apply the strict statutory language, comparable means similar, alike. And it doesn't have to be identical. If the legislature wanted PSP to have to match each element to each other, they would have used identical or equivalent, which is used elsewhere in the statutory scheme.
Fair enough. So it's comparable.
Yeah, that was the question I had.
Yes, Justice.
I believe you pointed to other examples where the legislature uses equivalency rather than whether it's comparative.
Correct.
Okay.
And it is used.
Thank you, Mr. Portman, very much.
Thank you, Your Honors.
Appreciate your candid answers. Mr. Jens, you can see we understand what's a very narrow question. Feel free to clarify anything that we don't understand, and we'll be in good shape.
May it please the court, Attorney Richard Yance on behalf of the appellee. I believe the court understands the briefings and the position of the appellee in this case, that the most fair, reasonable approach is a categorical approach, and there's reasons why that makes sense. But there are a couple of particular factors about this case that I think the court needs to keep in mind. One of the issues in this record is I don't believe this court would have to adopt a full categorical approach to grant relief in this case. While I do believe it should, one of the issues we have in this case is that the Pennsylvania State Police, from the beginning of this matter, has never even given negligence in the military statute due consideration or fair consideration. They essentially had a clerical decision made by an employee of the Megan's Law section, and even in their briefings to this court, continues to ignore the negligence portion of the military statute. And what we have in this case is a military jury, a court-martial panel, that rendered a decision where they could find guilt on the purpose of negligence. And even if we were to engage in the kind of factual analysis that Pennsylvania State Police is asking us to do, which practically I'm not sure how we would do that, in this case, a critical fact is that the very same military panel that voted to find the appellee guilty sentenced the appellee to a mere 60 days of confinement. In the military system, in this case, it was the court-martial panel that does the sentencing. So again, while I believe, and I think it's been briefed extensively, that the categorical approach is a means by which we can have a fair, predictable way of doing this kind of comparable analysis, I do think that this court doesn't even have to reach that in this case. And the last thing I will say is, despite the Pennsylvania State Police continued discussion and attack of the Commonwealth Court's opinion, saying they're using an equivalency standard, the Commonwealth Court repeatedly, in their own decision, in their own opinion, says comparable. And that's what the Commonwealth Court focused on. So,
well, they use the word comparative, but you could certainly infer from parts of the opinion that they're really looking at equivalency. Do you agree with that?
I think that you could, but when we're talking about something as critical as mens rea, that is something that we accept in common law as critical, we understand the difference between first-degree premeditated murder and negligent homicide. I think that would be critical. So whether we looked at it and said the court was using too high of an equivalency standard, I still think we get to the right outcome. But
so you're saying whether we use equivalency or whether it was comparative, you win either way?
In this case, absolutely. And any other result would be absurd when we look at the mens rea.
Well, it's not that it's equivalent or comparative. It's the language says comparable. And given that we're dealing with criminal mens rea, it's not a conversation we're having on the street where you say, hey, did you read in the paper about that sex assault case? Yeah, and there's this other sex assault case. They're all sex assault cases. But here, this is criminal. We're talking about criminal mens rea, and that's all the difference in the world. It's not a conversation in the street about whether something's a roughly equivalent type of episode, right?
That's correct, Your Honor.
Does it make any difference in your analysis that we're looking at a SORNA classification, not a criminal sentencing question?
I think the United States Supreme Court looked at that in the Leocal v. Ashcroft and immigration proceedings, as well as this court in AS v. PSP, and I think there still has to be consistency. And we're talking about something so critical as mens rea, that consistency would still apply here.
Thank you. Counsel, along those lines, you seem to concede that the SORNA subsection H is punitive. We've not really decided that. That it's a civil consequence. I'm sorry. You're conceding that.
I don't think it matters for this case. I'm not conceding that necessarily, but
You're saying he has to register. You're just challenging the tier.
that's correct.
Okay.
So if this court were to affirm this case, what happens to the appellee vis-à-vis the SORNA statute in Pennsylvania?
I believe that if the Pennsylvania State Police did a comparative analysis, looking at the categorical approach, he would be a Tier 1.
Which is 15 years.
That's correct, Your Honor. That's right.
Which is one of the reasons Justice Donahue points out to you that we haven't decided if it's a criminal or civil just yet.
That's right.
I mean, I think he'd much prefer to do a 60 days in the brig than a 15-year registration with all the attendant consequences.
That's absolutely
But
correct,
that's a
Your Honor.
legislative determination, not a judicial determination.
That's correct, Your Honor.
Anything?
Thank you.
Thank you both for sitting through that prior case, and nice job on this one. Want to take a lunch break? Court's going to stand in recess with apologies for the last two cases, well, you never know, until 1 o'clock, which is 50 minutes. Apologize for having you wait. The morning was time consumptive, as you, if you were here, saw.
You always apologize for our need to eat.
Yeah, well, you know, in a better world, we'd be able to anticipate this and have you come at 1 o'clock, but we really don't know.
It's been a pleasure.
In this case of first impression, the court must examine whether Section 23.2 of the Department of Education regulations requires that a school district obtain approval for its transportation plan prior to its implementation, which is what the Commonwealth Court held, or whether the approval and disapproval can be retroactive when the department determines to reimburse or decline to reimburse the school district's transportation's costs, which I think is what the school district is contending. So with that, if I got the issue correct, go ahead and obviously we're a hot court.
Thank you.
Tell us why you should prevail.
May it please the court, Christopher Volz on behalf of the appellant Wilkinsburg School District. The Commonwealth interpreted Section 23.2 as requiring the school district, before implementing a new or altered transportation plan, to obtain prior approval from the Department of Education. In other words, the shall be subject to approval language in the regulation requires pre-approval by the department. We respectfully think that this is incorrect, and the parties have provided you with hundreds of pages of argument on the meaning of these 8 words. But it dawned on me last night that what I think the words mean don't really matter. Instead, we should look to the Department of Education's interpretation of the regulation it is required to implement. As found by the trial court, the department does not have a process or forms for school districts to seek pre-approval of their transportation plans, contracts, or agreements. Instead, at the end of the year, school districts like the Wilkinsburg School District submit a form known as PDE 1049 to receive reimbursement for its transportation costs. Accordingly, the department approves contract via reimbursement. It follows that the department does not interpret the regulation as requiring pre-approval. In our opinion, the Commonwealth Court should have deferred to the department's interpretation because this interpretation is neither erroneous nor inconsistent with the regulation at issue. And we know this because the requirements for pre-approval existed in previous versions of the regulations.
Counsel, I think Chief is his 2 minutes just about. Thanks.
Okay.
Trying to
I
follow
understand.
the rule. Okay, so here's what concerns me about this case, has from the first time I read it. Why isn't the Department of Education here? I mean, how is it that everybody is litigating the validity of the policy of the Department of Education without the Department of Education even being, I mean, they might be within hearing distance from where we sit now, but they've had nothing to do with this case. I mean, isn't the only question we have before it was whether or not the school district followed whatever procedures were in place during the school year?
Correct. We agree with that, and we believe that the trial court found that we did, as a matter of
That's
fact.
what I'm saying. I mean, how do you go any further without having the department here to defend their regulations or lack thereof, or their interpretation of their lack of an interpretation? Do you understand what I'm saying? I mean, it would seem that we don't have an indispensable party to answer the question as to whether or not the interpretation of the Department of Education is according to law.
Well, that's an interesting point. Section 1726B and C of the charter school law provide that if a charter school doesn't think that the district is providing the proper transportation, that they can petition the Secretary of Education and have him review. And if the Secretary of Education agrees that we aren't following the proper procedures, they can reimburse the charter school for its costs and take that amount from the district's usual subsidy or contribution.
And they did that, did they not?
They did not do that, no.
Okay, they did not ask for reimbursement for the expenses for the little kids, the younger elementary school students who they decided to transfer it on their own.
To the best of my knowledge, there has been no petition filed with the Secretary of Education
Okay,
alleging.
but I thought they did, but it's irrelevant, because there was a procedure to follow if there was a complaint about the transportation that was being provided.
We agree, yes, we agree. 1726 B and C of the Charter School Law.
So I guess this would be more properly asked to the other side, but if you don't prevail, then what do we have, 500 school districts in Pennsylvania? And every one of them, I think, save my home district of Mount Lebanon, buses, and so those 499 or 498 are all going to need prior approval, and there's no mechanism for it.
Taken to its logical conclusion, every contract, every amendment would need to be approved by the Department of Education ahead of time.
And the Wilkinsburg School District is going to be the entity having that decision made without any participation by the Department of Education.
I don't quite,
I mean, no offense to it's a wonderful school district, and you're a wonderful lawyer, but I mean, with a decision of that potential magnitude, it would seem to me that you would absolutely positively need to have the Department of Education as part of that kind of adjudication.
well, yeah, we did not join
Not your
them.
fault. I mean, it might not be anybody's fault. You know, it's not a question of fault, it's a question of the case as we currently find us before, you know, that we have before us.
We did have district testimony from its employees regarding the filing requirements and what is required by the Department of Education. And the trial court did find, based on that testimony, you know, that there are no requirements for submissions for pre-approval. So,
In other words, you followed the procedures that were set up to follow for providing transportation.
to the best of our belief, yes. And that was what was surprising about the Commonwealth Court's ruling, is that it found that we didn't follow a procedure that does not exist.
Okay.
So where are you now?
While
Are
this
you-
case
Are you
is-
complying with the, are you seeking pre-approval? Are you continuing to bus and you're going to wait till June and apply for retroactive approval?
An interesting development. Prior to the masking litigation, we were unaware that an appeal from the Commonwealth Court to the Supreme Court by a governmental entity acted as an automatic stay. So what we did over the summer, after filing our petition for review, is we wrote a letter to the Department of Education saying, you don't have a process to do this, but the school year is approaching, and here's what we're doing. Our opinion is that it complies with the school code. Please give us pre-approval. And they responded saying, with the caveat that this is pending before the Supreme Court, your plan is approved.
What's that?
The plan was approved provisionally, pending this appeal.
Tough criteria. All right.
You said that so softly, I wasn't sure. The plan wasn't.
The plan was approved with the acknowledgement that this appeal is before.
Probably
the court.
fortunate that we don't have a case or controversy clause in our Constitution. This may be moot.
Well, yes and no,
Although it's capable
but,
of repetition and evading review, so.
and I think there are some underlying issues that would have us right back in court, because there were 3 issues before the Commonwealth Court, and it only ruled on this one.
What did they not rule on?
They didn't rule on whether the school district needs to provide identical transportation to its students and the charter school students, and whether or not it complied with 13, or the section of the school code regarding unsafe walking routes.
So factual questions.
Factual questions. Trial court ruled in our favor. The Commonwealth Court did not rule.
I think you've answered the justice's questions. Is there anything else you want to say?
No, thank you, Your Honor.
Thank you. Oh, I'm sorry. We got a question.
I was just curious as to whether there was any discussion or whether it's implicit in this approval, whether the transportation form that's picked has the same safety standards and requirements for the children. It was concerning to me just as I was reading it, I guess as a mother, that you would be putting kindergarten and early elementary children on a public transportation system without the type of safety guards that the school buses have, for example, the crosswalking guards and the flashing lights and whatnot. Is that even a consideration here?
For this argument, I don't believe it is. I think it's an interpretation of the regulation, whether or not we need pre-approval. I think that's something Mr. Strasburger will raise if this case is remanded to the Commonwealth Court. But our approval essentially said, the school code has you look at 3 factors: the distance walked, whether it's a common carrier, a school bus or something, or private conveyance, and whether there are any hazardous walking routes determined by the Pennsylvania Department of Transportation.
All right, the age of a child's not
It
considered.
is not in either the statute or any regulations.
Thank you very much.
Thank you, sir.
Mr. Strasburger.
Mr. Chief Justice Behr, and may it please the court, I'm David Strasburger. I represent Betty Bell and Propel Schools. At page 355A and 356A of the reproduced record, the district's transportation director was asked if the district is taking greater care to protect students who attend Wilkinsburg Public Schools than it is taking to protect students who live in Wilkinsburg but attend a Propel charter school. After receiving an objection to relevancy, which was overruled, the trial court announced, quote, "It's obvious to me the answer is yes, but I'll give that the weight that it deserves." The court then entered a factual finding, and that's plaintiff's proposed factual finding, which the court adopted, 56, that the district takes greater care to protect its resident students than residents who attend a Propel charter school. Now, often lawyers who come before this court argue about whether an iniquity can be remedied by this court or whether it's for the General Assembly. We don't have that problem here because the General Assembly authorized rulemaking and the Department of Education published regulations. So the question presented by this appeal is whether the Department of Education's Regulation 23.2, which says that the means of pupil transportation shall be subject to approval by the Department of Education, covers this obvious iniquity. We think it does. Surely safety is the paramount consideration when educating school children. Safety first, safety last, safety always. Surely the Department of Education has something to say about that. I'm happy to entertain questions.
Don't you have to be here, Mr. Strasburger? I mean, back to my question. How do we interpret a regulation of the Department of Education without having input from the Department of Education? More importantly, how would we say it's invalid or it doesn't cover these situations? How could we do that without the Department of Education being involved in this litigation?
Your Honor, I do not know why the Department of Education is not here. We did not sue them.
Well, that's why they aren't here.
Well, but they could, they're aware of the litigation.
For intervention.
They could have asked to intervene. They could have filed an amicus brief. They have run away from this litigation.
Have you filed have you used the procedure set forth in the charter school law to get reimbursement for the alternative transportation that you provided under your interpretation that what Wilkinsburg was doing was improper under the department regulations?
We have not, Your Honor, and Mr. Volz, my friend Mr. Volz, is correct that there is a procedure under the charter school law that says that we can go to the Department of Education and request reimbursement if they're not providing appropriate transportation for our students. But that's not an exclusive remedy, and we litigated that in the trial court. They filed preliminary objections. They said, this is your exclusive remedy. The trial judge overruled that objection, and so it was never raised again.
May I ask you, Mr. Strasburger, as I'm sure you're well aware, the charter school law does provide for cities of the first class, which is Philadelphia, that it must get prior approval of its busing on or before August 1st of each year for the succeeding school year. By sort of negative corollary, it would seem that, and I agree with my colleague Justice Donohue that I'd like to hear what they have to say, but it would seem that they have interpreted the broad requirement in the applicable registration that the plan shall be subject to the approval by the department as providing approval retroactively when they approve or disapprove implicitly there, and that would be within their province, and that doesn't violate the law, which is the only thing that's of concern to this court.
So
which I guess would make us a reverse, and so where have I gone wrong?
So I think we're talking about two separate things there. One is the City of Philadelphia, which is first class. There is something specifically in the charter school law that says when they have to file their transportation plan, and I agree with that. But we have to remember that this regulation has been on the books since 1971. And so what the charter school law says about when the transportation plan has to be filed for Philadelphia really isn't an interpretive clue into what a regulation that was passed in 1971 really means. But you can see from the history of the development of the law from this court's decision in Rose Tree Media, which says approval of the cost of reimbursement is not the same thing as approval of the means of transportation. And so all that's happening when you approve the costs is that there has to be some other pre-decision that approves the means of transportation. And that's how the regulations have been set up for the past 50 years. There's been a lot of briefing on what happened in 1989 and how the regulations were segregated. Actually, they were segregated in the 70s, but they all say the same thing. The means of transportation from the very beginning is subject to approval by the department. And the contracts that are entered into by the school district have to be approved by the department. And the reason we want the Department of Education to approve these transportation plans is because we cannot leave it to the school districts to just decide without any government oversight at all what is safe for our school children.
Why don't you just get the department to revise its rule and add the word prior? Why are you coming to us to ask us to insert a word that's not in the rule rather than lobbying them and go through the notice and comment procedure, et cetera, to get the word in there? Who are we to just throw a word in there that's not there?
So, Your Honor, if I settle a case with Mr. Volz and I say, this settlement is subject to my client's approval, everybody knows that the word prior doesn't need to be in there. I can't settle it with him if I say it's subject to my client's approval. If I'm buying a car and the salesperson says, we've got a deal, but it's subject to my manager's approval, then there's no deal unless he gets the manager to come in and say, you got a deal.
Those are fine examples. Here we're talking about how many school districts do we have in the Commonwealth?
I'm sure there are 500.
Okay, so it might be fair to speculate that a whole lot of them don't comply with this before the first day of school. What does that do to their transportation regimes?
I think that the Commonwealth Court was cognizant of the administrative issue and said if it's a new plan or an altered plan, then you need to get Department of Education approval.
Prior approval?
Yes, prior approval.
Where does the Commonwealth Court or anybody else come in to create out of whole cloth a judgment as to what category will have prior approval, meaning what you just said, and what other category will require something less? I guess by implication, what does your position and the Commonwealth Court's outcome mean as we move down the line going forward, and the fall comes around, and X number or Y percent of the districts are just out of compliance with your new invention of what approval means, that it requires prior. I mean, I think it's fair to speculate there's going to be some non-compliance. I'm interested in knowing the implication of what that would mean under your approach.
The implication, Your Honor, is I think that the Commonwealth Court was trying to balance a prospective rule so that there wasn't total havoc going forward with the language of the regulation and, frankly, the Department of Education's failure to follow its own regulation. So I would respectfully say that if there is going to be chaos, it is the chaos that is the making of the Department of Education. And we should not try to recognize that as a reason to interpret the regulation in a way that really doesn't make any sense. Because if it's just subject to approval and you submit your form for getting reimbursement, and that's all that means, I would respectfully suggest that that is not really oversight by the Department of Education, and it's not consistent with the history of the administrative regulations.
But counsel, you could be 100% right, except for the fact that the Wilkinsburg School District followed every procedure in place for them to get transportation on the road for kids in their school district. I'm going to say it again. Your gripe is with the Department of Education. I mean, it is totally beyond anything that, I just don't think I've ever seen it. You're using a straw man to attack the procedures that the Department of Education is following. And back to Justice Weck's point, it doesn't say prior approval. The Department of Education could have a very good reason for the reason they do it the way that they do it. I mean, who would know sitting here as we sit here today? So I can get back to my point. What did Judge O'Toole do wrong with the evidence?
O'Brien.
O'Toole.
O'Brien.
O'Brien, I'm sorry.
O'Brien.
What did Judge O'Brien do wrong with the fact finding in this case? He had testimony of here's how we get approval. Here are the forms we have. These are the only forms available. These are the forms that we use. We submit them, and once it's paid, we know that, what we did was approved. And the judge said that's correct. I don't have any contrary evidence.
So no one from the Department of Education testified, that's true. And the only witness who testified on that subject was a Wilkinsburg witness who said, to the best of my understanding, there was an objection, to the best of my understanding, this is the only procedure in place.
Okay, so, I mean, that's, they were left with the facts within their knowledge. And it works. They get paid at the end when they submit it. I mean, I'm not, the merits of your argument are you have valid points to make. The Department of Education may have valid points to make as to their interpretation of what they're required to do. I'm at a loss as to how we decide the legal issue that's been presented to us here, that it requires pre-approval. I don't know.
So I would just say that this is like any other administrative regulation in the Commonwealth, that the judicial branch has the authority to interpret. And
Go ahead and finish. I apologize. I started to talk, but I want you to finish your answer to Justice Donovan.
Thank you, Your Honor. And so we argued for equitable relief, that they had not followed the administrative regulation, that if the Department of Education does not like that interpretation, they can follow the Commonwealth Documents Law and repeal it.
They aren't in the courtroom.
They're not in the courtroom, but they're not in the courtroom all the time when we try to implement administrative regulations.
I think the inference is probably that they're well aware and they'll see what we say and they'll do either one, and they don't much care. I mean, that's just an inference. That may not be correct, but that's what I draw from the fact that they didn't bother to come and participate. May I ask you, it seems to me that the regulation is the means of pupil transportation shall be subject to approval, and that you equate that with student safety. And think what this is really about is student safety. And I'm sure there's nobody in this courtroom, and I doubt there's anybody in the Capitol, that maybe in Pennsylvania, that doesn't care about student safety and child safety. Is there other, to your knowledge, other regulations, other state laws that deal with student safety as opposed to the means of transportation, you know, bus or Port Authority, school bus or Port Authority card or taxi or Uber or the like?
So,
if you know.
there are a number of regulations that address licensing of teachers. There are a number of regulations that address who can perform certain functions in a school. And all of those are addressed to the safety of the particular student. So there are, in addition, rules about what I think my colleagues, amici from Mr. McKenna's brief, said on what traffic controls must be followed when a bus is on the road, and what can qualify as a school bus. It's got to have an arm that goes out, and it's got to have a stop sign, and it's got to, all of those things are.
So there's lots of other safety regs. Your concern is the means of transportation might jeopardize safety. You know, one could argue, as I said at the outset, that my home community, which, and you're from Pittsburgh, may be one of the only in the state that doesn't bus anybody ever, could put people in safety, because we also don't have sidewalks. But parents get their kids to school. I don't know, do you live in Mount Lebanon?
I don't, Your Honor, but I did live in the East End for a long time, and I watched the kids who took the bus down Fifth Avenue, who got off at Central Catholic, okay? And we're not here arguing about high school kids.
Right.
We're arguing about grade school kids.
Thank you for indulging me. Justice Todd has a question.
Mr. Strasburger, could you clarify for me, how do we know, or do we know, when we read shall be subject to approval by the department, whether it's referring to the means of, it says student transportation shall be subject. Does that mean the means of transportation or the costs of the transportation, or does it mean both? And how do we know that?
So the regulation starts with the means of pupil transportation, and then there is to and from school, and then there's a dependent clause. Actually, there's two dependent clauses, ending with shall be subject to approval by the department. So I think as a amateur grammarian, I would take out those two dependent clauses and just say the means of pupil transportation to and from school shall be subject to approval by the department.
But we're also arguing, are we not, about approval of invoices, approval of the cost, or not?
So those regulations exist, but they're further back in Part 23 of the regulations. So in 1975 or 6, the Department of Education segregated approval of the costs in their regulatory regime from approval of the means of transportation.
And according to one of our amicus, the Pennsylvania School Boards Association, for the past 30 years, advanced approval of transportation plans has not been required.
They've said that, and they rely upon what happened in 1989. And it's important that we pay attention to the comments in the Pennsylvania Bulletin about what happened in 1989, because they've made an important concession. They said prior to 1989, the Secretary of Education did approve transportation plans.
From 1972 to 19.
Correct. And that changed in 1989. But what they point to is a comment from the Pennsylvania Bulletin where the Department of Education says, these changes are not substantive. We're reordering the regulations because they're repetitive. And so the inference that they're drawing is really not an inference that supports their position, because when the regulations were changed, they weren't changed substantively, they were changed merely because they were repetitive.
But a prior iteration did have the word prior. I'm sorry. Excuse me.
Or because they were no longer necessary, not necessarily that they were that they were repetitive.
So I am looking at November 4th. Sorry, these are not great copies. November 4th, 1989, Pennsylvania Bulletin, page 4729 of volume 19. And it says, the purpose of these proposed amendments is to clarify and update language, provide districts the discretion to allow minor children of bus drivers to accompany them, and then it says, and delete regulations which are not necessary or no longer effective.
So it doesn't say that are repetitive, but.
Well, it does on the next page.
Oh, go ahead.
So you go to page 4730, and we're talking about the language that they're saying supported the original interpretation, that you must submit them to the Secretary for approval. And it says 2321, which sets general procedures for Department of Education approval of transportation arrangements, is proposed to be deleted. Subsection A is repetitious of section 23.2, which is what we're litigating here.
That's a good point. But what it comes down to is, as a practical matter, for the past 30 years, it's not been, advanced approval has not been required, that we know of.
That we know of, there's nothing in the record other than the testimony of the Wilkinsburg witness who says this is how it's done.
Well, and the amicus brief.
I'm sorry?
And the amicus brief from the Pennsylvania School Boards Association.
Yes, that is what they've said.
And then there's also the fact that in all that time, the word prior was never put back in. So there's that.
So the word prior, Your Honor, is in other places, like 23.47, okay, and like approval of contracts with common carriers.
Which way does that cut?
I think
The fact that it's elsewhere but not here, which way does that cut?
on the contract, there is no contract here. I mean, I'm not sure which way it cuts, because it says quite clearly that the Secretary has a role to play in some of the features of transportation, that it goes beyond cost. If there isn't anything else.
Anything else? Thank you, Mr. Strasburger, appreciate it.
Thank you, Your Honor.
You know, I know you've heard many times before that hearing your voice reminds us all of your wonderful late departed, terrific dad.
Thank you, Your Honor. I miss him every day.
As do
Thank you. In this interesting case, Synthes filed a refund petition related to its 2011 corporate net income tax. At issue in that matter is the proper allocation of its sales of services between Pennsylvania and other states for purposes of determining its income taxable in Pennsylvania. Synthes has also sought to utilize an allocation method consistent with the Department of Revenue quotes, presented an argument contrary to the Department of Revenue, which is an executive agency of the Commonwealth, prompting the department to intervene. So, as I said, in this interesting case, we granted oral argument limited to 2 questions. First, whether the Office of Attorney General is authorized to represent the Commonwealth, taking a position inconsistent with that of the Department of Revenue's interpretation of the relevant statutory provision. And second, once we get that straightened out, what is the proper method of allocating the sale of services under the Pennsylvania tax code? So if I got that right, please feel free to proceed.
Mr. Chief Justice, Justices, may it please the Court, my name is Sean Kirkpatrick. Mr. DeLone is with me at the Council's bar, and we are with the Office of Attorney General representing the Commonwealth of Pennsylvania. My friend is from the Office of General Counsel representing the Department of Revenue, and that distinction is where I'd like to begin this afternoon. This tax case asks fundamental questions about the structure of our government. The Commonwealth Court incorrectly held that the Attorney General was bound by the Department's construction of the statute at issue, notwithstanding the Attorney General's own contrary interpretation. The Department makes this a jurisdictional issue, arguing that we do not even have a voice in this case. The fundamental error made by the Commonwealth Court and the Department of Revenue is analogizing the OAG to a private law firm. We are not like a private law firm. We are not a duplication of the Office of General Counsel. The Attorney General is an independent constitutional officer directly accountable to the voters. And the assertion that we must act merely as a mouthpiece for the governor's legal positions is at war with the language of the Pennsylvania Constitution, the language of the Commonwealth Attorneys Act, this court's precedent, and over 40 years of an independent Attorney General representing the Commonwealth in a variety of different cases. So we begin with the founding charter because the independence that is granted to the Attorney General in our Constitution is woven throughout Pennsylvania law. So before 1978, the Attorney General was a member of the governor's cabinet. But in May of 1978, the voters overwhelmingly chose to make the Attorney General independent and the chief law officer of the Commonwealth. The duties of the Attorney General were then implemented in the Commonwealth Attorneys Act, which explicitly says that the Office of Attorney General shall be an independent department. We have the exclusive primary responsibility to conduct all litigation on behalf of the Commonwealth and all Commonwealth agencies. But because of that independence, there may be times when the Attorney General and the Governor disagree on legal issues, and the Commonwealth Attorneys Act provides for that specific instance. In Section 303 of the Commonwealth Attorneys Act, it provides that if there is a disagreement, the Governor may ask the Attorney General to supersede. If the Attorney General denies that request, then the General Counsel may require, or the Governor may require the General Counsel to intervene on behalf of the agency, quote, to represent the Governor in his interests. And this is while the Attorney General shall, quote, at all times continue to represent the Commonwealth, because we are the Commonwealth's attorney.
Counsel, before you move on to another section, obviously, whatever the Attorney General can do is pursuant to the authority that's granted to the Attorney General under the Commonwealth Attorneys Act. Do we agree with that?
Yes, that is, I think there are a couple other statutes, but for the purposes of here, yes.
Okay. Here's my confusion about the Attorney General's role in litigation. And we agree that the section that we're talking about talks about the Attorney General representing either the independent agency or the governor or the Commonwealth, correct?
That's correct.
Okay, so let's put that aside for a moment. That's in 204, and maybe 303 also uses that same
Yes.
language. Okay. I'm looking at section 204A, which is called legal advice.
Yes.
Okay, so the Commonwealth Attorneys Act distinguishes between the Attorney General acting, representing, let's say here, the agency, or whoever it is, distinguishes that from the Attorney General providing legal advice. Are you with me so far? Section A1 says, upon the request of the governor or head of any Commonwealth agency, the Attorney General shall furnish legal advice concerning any matter which happens to include actions or issue arising in connection with the exercise of the official powers or the performance of the official duties of the governor or agency. If the governor requests advice and the Attorney General gives it, the governor has to follow it. Okay? Now, that is the Attorney General acting as an advisor, including in litigation.
No,
That's what it says. A matter is defined in section 101 as an action.
The legal advice in that provision is upon request by the governor, the Attorney General provides that advice, and the governor is bound and would have to appeal it to the Commonwealth Court in order to overturn that advice.
And just as clarification, you provide that in an official, I can't remember what they call it, but you do an official written document, you compile them at the end of the year and publish them in a book. So it's not like you have a phone call with the governor?
No, not at all. This is official, it is published. I can't say off the top of my head when the last time we were requested for advice is, or when we had the opportunity to publish this. But
it may be back when the Attorney General was actually the governor's lawyer, which was prior to the independent election of an Attorney General.
that's correct, Your Honor. So
Does that help at all with Justice Donahue?
It doesn't help me.
No?
No, it doesn't help
I
me
thought
at all.
maybe you were
No,
passing
it-
in the
no,
night
no, no,
because
it
of the
doesn't-
nature of how they give advice.
I understand the desire to paint with a broad brush here, but there is statutory language because the section that I just read to you was request advice concerning a matter or issue. But let's just focus on the term matter. Request advice on a matter. Matter is defined in section 102 as an action, proceeding, or appeal. And it seems to me in reading this is that the only way, at least the agency, is bound by the advice of the Attorney General is if it asks for that advice. It's what it says.
Your Honor, if the Attorney General, the issue here is not whether the agency is bound. What is at issue here is whether the Attorney General, in fulfilling his constitutional duty as Chief Law Officer, may have his own mind or not during representation of the Commonwealth and Commonwealth agencies. So if it was the case in which the only way we could have our own mind was if there was an official request that would result in a published opinion from us, then 303, which says that if there's a disagreement, the General Counsel can intervene and the Attorney General shall at all times continue to represent the Commonwealth, would never occur. It would also be...
Let me ask you that question. Is it true that that never would occur? Because aren't many actions, and I'm going to use that word, action, aren't many actions brought against an agency and the Commonwealth? in which case you would continue to represent the Commonwealth, whatever that means, if an action is also brought against the Commonwealth. But in a situation like this, when an action is brought against an agency, which is how I think you would qualify what happens here in the underlying tax matter that was adjudicated?
I would not, Your Honor, but you can finish your question, but
What would you call it?
it is as the fiscal code makes clear, it is the Commonwealth of Pennsylvania. It is not the department.
No, but what would you call the underlying, when the matter is brought before the Board of Finance, would you call that an action?
An administrative action, yes.
Okay, so that would be, that is an action.
Yes.
So in that circumstance, the Commonwealth, independent of the Bureau of Finance or the Department of Revenue, is not a party, correct?
Yes, the Commonwealth does not get implicated until, and this is Section 503 of the Fiscal Code, it defines the type of entities that can be aggrieved by a decision of the Board of Finance and Review and may petition. And that is, and it's a list of debtors, or the Commonwealth of Pennsylvania. The Rules of Appellate Procedure make clear that the respondent shall be the Commonwealth of Pennsylvania. And I would point to the Taxpayers' Bill of Rights, which we talk about in our reply brief, which provides that should the Commonwealth not appeal a decision by the Board of Finance and Revenue, the department may not make an assessment against the taxpayer that raises an identical or substantially identical issue. So there is a recognition in the law that the Office of Attorney General, and this is how it actually works, if the department feels that they wish to appeal a Board of Finance and Revenue matter, they come to the Office of Attorney General and they ask us to file the petition for review because that is our obligation and we're representing the Commonwealth. If we say no, that ends it, and that does not get appealed. And that is, like I said, the Taxpayer Bill of Rights and the recognition in the Fiscal Code that it is the Commonwealth, not the Department of Revenue, which is actually the party at issue. And the reason is, Your Honor, is because it's the Commonwealth's money that is at issue in these types of tax cases.
Counsel,
But
can I just follow up?
sure.
And that's why this imprecise language, it just confuses me. You could be exactly right, but I'm confused because the statute that we're talking about calls for the Attorney General to represent the agency in an action.
That's correct.
An action is not an appeal.
I disagree, Your Honor.
I'm looking at the definitions.
Yeah.
I mean, I don't know how else to, I keep getting back to, I don't mind, going along with your interpretation. I'm just trying to trace it in the Commonwealth Attorneys Act.
Sure. So action is defined as any action at law or equity. That is what an action is defined as. Matter is defined as action, proceeding, or appeal. So the argument on the other side is because it differentiates between action, proceeding, or appeal in matter, an appeal cannot be an action. That would lead to the following. Because the Attorney General's office can only litigate or represent the Commonwealth and executive agencies in actions, not only should not be in front of you, but for the past 40 years, the Attorney Generals should have not been litigating any actions in any appeals before this court.
Did your office represent the Department of Revenue before the Board of Finance?
No, Your Honor.
Okay.
We did not. That is an administrative. Sorry.
So you entered your appearance, so to speak, on appeal.
When this appeal was taken, it was against the Commonwealth, and under the Rules of Appellate Procedure, we were notified that an appeal had been taken, and we entered our appearance on behalf of the Commonwealth. That's exactly right. Now, the action and matter definitions, and we discussed this in our brief. I don't want to make too much of a point on this, but those definitions are verbatim from the Judicial Code. Now, in the Judicial Code, the code actually defines what an appeal is and what a proceeding is as uniquely separate. In the Commonwealth Attorneys Act, there is no definition for appeal or proceedings, so we would argue that you take the common understanding of it, and that is that an appeal is part of a civil action.
There's been a lot of water under the bridge since I had a pointed question to what you said, but let's forget all of that. One of the problems here is the governor was not involved as a referee between revenue and OAG. But just assuming, because General Counsel is here, that the governor was sub silento here, I think I agree with you. This case comes down to 303 and 304. 303A and B. Is that your view of it?
Yes, there's a corollary in 403 for independent agencies, but
right.
Yes, but
this is not an independent revenue.
No, you're exactly right, Your Honor.
And so under 303B, the statute, the Commonwealth Attorneys Act seems to contemplate this dual representation.
Yes.
Is your argument as easy as that?
It truly is, and if I can just repeat the court's own words back to it from Fidelity Bank versus the Pennsylvania Turnpike Commission, which was an independent, not only does the act, quote, not compel the ouster of the Attorney General when agency counsel intervenes, but the act contemplates the possibility of dual representation where the Attorney General and the members of an agency disagree as to the agency's interests. And we're not asking for deference. What we are asking for is a voice, and to be able to provide to the court our legal perspective, just as my friend will provide his legal perspective as to the understanding of this statute. Now, in most...
And we get to break the tie.
Absolutely, Your Honor, as in all cases. And this, in most cases, we are completely in accord. And so it doesn't matter. In the rare instances where it does matter, it is important that the independence of the office be maintained. And if I can just take it very briefly outside of the tax context, 7 days ago, the U.S. Supreme Court decided a case called Cameron versus EMW Women's Surgical Center. And that was dealing with Kentucky, and it was dealing with the ability of intervention at an appellate level. But what struck me in reading that case was the U.S. Supreme Court's recognition that in Kentucky, like here, you have a popularly elected Attorney General. In Kentucky, like here, he or she is the chief law officer. And in that case, it was a situation where a statute was challenged. The Attorney General was representing the Secretary of the Department of Health, and everything was going along up to the Sixth Circuit, and then there was an administration change, and the Secretary of Health says, I don't want to continue defending the statute. And the Attorney General said, okay, well, I'll intervene, and the Sixth Circuit said you couldn't, and in reversing, the U.S. Supreme Court said, respect for state sovereignty must take into account the authority of a state to structure its executive branch in a way that empowers multiple officers to defend its sovereign interests. It is the Attorney General who is deemed Kentucky's chief law enforcement officer and the authority to represent the Commonwealth in all cases. We would say that the voters of Pennsylvania in 1978 made a similar decision to create an office that is independent of the governor in order to provide, in those rare cases, an independent legal perspective, or should the governor and his agencies decide not to defend a law, that there would still be a voice to defend laws who cannot defend themselves in court.
We understand your point. There being no other questions, why don't you turn to whether we should adopt, I think, your preferred cost of production method or revenue's preferred benefits received method.
And I would much rather live in the Commonwealth Attorneys Act world than the tax code world, but
Isn't that the point? Isn't that the point? That's why we have agencies who are given the authority to become expert in those areas.
you're absolutely right, Your Honor, and we discuss with them at all stages, and in fact, in this case, they knew we had a contrary decision before or a contrary view of the interpretation of the statute before our brief was filed. We work very closely with our agencies, but it is our constitutional duty to represent the Commonwealth and Commonwealth agencies in court.
Turn to the merits, please.
So, this is all about sourcing the sale of services. And it comes down to subparagraph 16, which talks about the sale of tangible personal property, in which the General Assembly made clear that you figure out how to, what taxes should be paid because they're in Pennsylvania and what taxes shouldn't be paid because they're out of state. They said that with tangible personal property, it is the sale of tangible personal property are in this state if the property is delivered or shipped to a purchaser within this state. So it is based upon where is that delivered. Toaster oven, any kind of tangible personal property. 17, which is the paragraph that we're talking about today, which deals with everything else, including services, prior to 2014, uses very different language. It doesn't say, as the General Assembly said very easily when they amended this to pull the sales of services out of 17 and put it in 16.1, that if a service is delivered to a location in the state, then it's sourced to the state. They easily could have done that. Instead, what they said was, there's two sections, A and B. The income-producing activity is performed in this state, or the income-producing activity is performed both in and outside of the state, and a greater proportion of the income-producing activity is performed in this state than in any other state based on the cost of performance. So the entity that is experiencing the costs of performance of the income-producing activity is the taxpayer, not the customer. The Department of Revenue focuses too much on the word performed at the cost of all of the other language, cost of performance of the income-producing activity. And that can only be the taxpayer. And so, in trying to understand this, because we have to give full effect to all the words, so the question becomes, if you're just basing it upon the ultimate customer, when does 17B come into place? Because it's where the customer resides. The example that Department of Revenue came up with in their brief was an actual service that spans state lines, because it has to, under their interpretation. It was a snowplow that plows a highway that crosses state lines, but even that wasn't sufficient, because then presumably 50% would be in Pennsylvania, 50% would be in New Jersey, so they had to add a couple parking lots on one side in order to actually bring it under 17B. That is not the intent. The intent was to cover service providers who, let's say that you have a architectural firm, it's based in Virginia, but it's dipping a toe in Pennsylvania. It has a small office in Pennsylvania, a couple of employees. The sourcing would be, what is the greater amount of your cost of performance of your income-producing activity? That would be in Virginia. If the reverse was true, then it would be in Pennsylvania. And that's giving the full effect to 17A and 17B. If the court doesn't have any questions, we stand on a brief on that subject.
I wish I knew enough to ask a question.
If the court is confused about an issue, I'm happy to answer that question.
What did the Commonwealth Court do in this case on this issue?
They deferred to the interpretation of the Department of Revenue.
So you're appellant on both issues?
Yes, Your Honor.
Okay, thank you. Anybody else, anything?
Does the department reserve some weight given to their interpretation because they are the department?
Not in this instance, Your Honor. And the reason I say that is because this was an unwritten policy that was not published, and that is, it's internal memos, not publicly available. That's 72A of the record.
But if you look across the history of how the department has interpreted the section, haven't they consistently done it in this manner?
Yes, Your Honor. Yes, Your Honor.
And in furtherance of that, I think Justice Mundy makes a wonderful point and jog my memory. Just by analogy, we had a case, and I think your office was involved some years ago, as to whether or not gas is a mineral or not. And there was 100 years of history saying gas was a mineral, notwithstanding it can move from here to there. And I think the court decided that we weren't going to tamper with 100 years of history, which all of industry had relied upon and everyone had relied upon. Well, here, as Justice Mundy points out to you, I don't know that it's 100 years, but there's many years of history. All the taxpayers know that the department uses the cost of production method, the benefits received method, and I think I think that the implication was that we're going to unnecessarily upset a settled methodology of doing business, which all of the businesses of Pennsylvania, as well as the department, knew. And that's a concern. And that's the concern Justice Mundy raised and jogged my memory.
Absolutely. If I could speak to that concern. So, to begin with, not all taxpayers understand that. In fact, Synthes in this case didn't understand that because they properly paid their taxes based upon the clear reading of the statute. They, I'm no doubt, have very intelligent accountants. They read the statute, as we did, and said, no, it's based upon the sourcing of where you incur the costs, not where you're located, which is why they're asking for a refund. So to say that everyone knew this and has been playing by the same book, I think betrays the actual facts of this case. But to your point, we have separations of powers, and the legislature gets to determine public policy. It is no doubt. Let me soften that a bit. We're not here to say that a certain interpretation is better public policy than another. That is, again, for the General Assembly, and the General Assembly made that determination in 2014 when they amended the law. What we are saying is that the text of the statute needs to mean something, and the intent through the clear words of that statute need to be defended, and we believe it's our constitutional duty to do so, but also that an executive agency cannot rewrite laws simply because they've done it for a long time.
But you raise another point in my last one, which is revenue added 16.1, I'm sorry, the legislature added 16.1 in 2014. Yes. I suspect, and I don't know, if we go back and check, revenue was using the benefits received method substantially prior thereto, and the legislature did not strike paragraph 17 or change, I don't know if it could change things retroactively. Perhaps that's the problem.
Well, retroactively, yeah, I think that would be a problem. But to the point, and I think the Commonwealth Court gets the chronology a little bit confused, it was not a situation in which the department publicly announced, this is what we're doing, and the General Assembly said, well, we're not going to change anything. They published their bulletin explaining their methodology on how they were interpreting this prior to 2014 after the amendment to the law. So there's nothing in this record, and in fact, I would again point to 72A to suggest that the General Assembly did not know that this was happening. So I do not think that the court should give deference based upon that.
All right, well done. There being no questions, thank you.
Thank you.
Mr. Joel, is that correct? And introduce yourself and elucidate us.
Happy to do so. Yes, Mr. Chief Justice, and may it please the court. My name is Kenneth Joel. I serve as a Deputy General Counsel in the Governor's Office of General Counsel, and I'm here today representing the Department of Revenue, the executive agency under the Governor's jurisdiction that was specifically created, quote, to exercise the powers, perform the duties heretofore exercised and performed by the Auditor General, the Treasurer, the Insurance Commissioner, all other departments, boards, and commissions of state government in the settlement of taxes, in the collection of taxes, and in license fees and other monies due the Commonwealth.
Sir, could you
Yes.
introduce your co-counsel?
I'm sorry, I was going to get to that in a moment. This is Mr. Gallo.
I didn't want to interrupt you, but it was a very long sentence.
Sorry, well, it was long quotation in the statute. This is Mr. Gallo. He's representing Synthes. I was going to get to our respective roles here in a moment. Get to that right now. I'm representing the Department of Revenue. I plan to speak today on the impropriety of the OAG's actions as it relates to offering a contrary position, one that conflicts with its client, the department.
Can I just ask, Counsel?
Sure.
I'm sorry, I have my mic off. What are we to make then of the language which appears at least twice, first in 732-303 and then in 732-403, quote, "The Attorney General shall at all times continue to represent the Commonwealth."
I'm glad you asked that. I was going to get to that a little later, but let me start right there. That's the supersession provision. Okay? There's no case that I'm aware of that interprets 303. There is a case that interprets 403, and that's Fidelity Bank. What I think is important to note
If I can just intercede, 303 and 403 are the same. The only distinction is whether it's part of the Commonwealth government or an independent agency.
there's some language that is different, but in terms of the continue to represent the Commonwealth, they're the same in that language.
So just in answering Justice Weck, make sure you explain why the precedent is not applicable here. The fact that that was the Turnpike Commission and this is revenue being a distinction without a difference.
To the contrary, I think it is applicable, and I think it governs this case, and it disposes of the Attorney General's argument. Because in that case, the Attorney General was representing the Turnpike Commission, not the Commonwealth, the Commission. The Chief Counsel of the Commission intervened. The question, quote, by this court, was the respective rights of the AG and Commission Counsel to represent the Commission in this litigation. It didn't create a new client. It didn't create a new entity. It didn't create a new vessel for the Office of Attorney General to become the client and press its positions. That's not what the case did. In fact, it looked at 204C, which we've talked about. It looked at Section 403. And in regards to 403, which is the language you're looking at, and it's the same as the Commonwealth language in 303, that Section 403, while permitting the AG to delegate that duty to agency counsel upon request, in no way affects the continued right of the AG to represent the agency, not a separate standalone client, not a separate Commonwealth entity, into which is a vessel for the Office of Attorney General to put his or her legal interpretation. What's more, it goes on and says the Act contemplates the possibility of dual representation, dual, of the agency. We reject the claim of the Commission Counsel that his intervention bars the AG from representing the Commission in this litigation. All throughout that case, the use of the word Commonwealth doesn't mean some independent, standalone, autonomous entity into which the Attorney General foists its view. It is the agency. That's what 303 says. That's what 403 says, as interpreted by Fidelity Bank. So I think that disposes of the supersession argument that the Chief Justice was raising, and that you're now raising, Justice Wecht. But to get back to the beginning, I don't know if you want me to tell you what we're each going to be talking about. We're kind of past that at this point, but.
I think we got it. You're
Okay.
doing the Commonwealth Attorney.
Well, I'm also going to argue that the department's interpretation of subparagraph 17 was correct.
Well, then it seems to me you're doing the whole argument, but go ahead.
Well, he has a separate client.
Yeah.
And it is a bit unique because the text.
Notwithstanding, and as you both well understand, we don't want to hear the same argument twice.
Understood, understood. So, getting to the Commonwealth Attorneys Act issue, we can look at the Pennsylvania Constitution, the Commonwealth Attorneys Act. The OAG's position is really breathtaking if you think about it, to be a necessary check on the executive branch. It's not a fourth branch of government. In all matters, to provide independent articulation on the law to the judicial branch. That's nowhere found in the Commonwealth Attorneys Act. And perhaps most remarkably, quote, or to be, quote, independent of control of the governor and general counsel in all litigation involving the Commonwealth and its agencies. That's vast.
Well, it is vast, but the Attorney General is elected statewide as the highest legal officer in the Commonwealth. I mean, if we don't view it that way, how do we review his role?
His role in this sort of a tax appeal?
His role generally.
I think
It's more of a
it's a law firm.
Very well.
It's a law firm. It's a law firm representing the governor and the agencies.
Represents the Commonwealth of Pennsylvania.
In an action, and this gets to Justice Donahue's question, action is specifically defined. Before I get there, let me talk about Garcia, because I think that really disposes of the AG's position here.
Well, just one
Sure.
more question. Who are the parties to this appeal?
The parties, the Department of Revenue and Synthes, which ironically, we're both on the same side of the V in this case.
Who are the parties?
The Department of Revenue. The Department of Revenue is, as we've just talked about with the enabling legislation, and as it relates to corporate tax issues, is the authority to deal with corporate tax issues, issue refunds, issues assessments, et cetera. It's the Department of Revenue. There is no separate Commonwealth. Who is that? What is
You're saying
that?
we couldn't even be here then? Like, if your position was right, you're saying we couldn't even be here.
I'm not sure I understand.
Well, I mean, just hearing you answer Justice Todd, I'm sorry to interrupt, I just wanted to jump in to just confirm then that in the context of this particular dispute, you having said they're just the law firm essentially, but if they couldn't proceed in this capacity and you happen to be aligned with Synthes here, therefore you're the sequel to that is that we wouldn't be here.
I see where you're going,
right?
and yes,
Is
that was the first argument that we made in our brief.
Or would you envision a scenario here where the AG could be heard nonetheless in some intervention theory?
I'm not sure if they could intervene, but to get to your first point, that's why we raised the jurisdictional issue in our brief. Yes, the parties before the Board in Finance and Revenue were the Department and Synthes. It's an appeal from that administrative matter. It's our position that the department remains the party. We're in lockstep on what the law means.
And I think you did do this, but I didn't follow entirely, and I want to give you every opportunity to attempt to persuade me. It seems to me that you lose relatively, and I'm being very candid, relatively easily under 303B, which contemplates dual representation, and under this court's precedent in Fidelity Bank. Again, tell me where I've gone so off the rails.
Because Fidelity Bank does not stand for the proposition that there is an independent commonwealth into which the Attorney General is representing and becoming the client.
It's not a question of independent commonwealth. It seems to me, and I don't want to fight with you, but I want to, again, make sure that I give you every opportunity to correct what I think. It seems to me that 303B contemplates, albeit unusual, dual representation of, quote, the Commonwealth, end of quote, and, quote, the Department of Revenue, end of quote, and that Fidelity Bank confirmed that by saying that the Turnpike Commission can have counsel and the Commonwealth can have separate counsel.
But that's not what Fidelity Bank said.
Okay, go
What
ahead.
Fidelity Bank said, and what I just quoted, was that the commission can have dual counsel, not the Commonwealth. The commission. It's a difference, and it means something. It's not that Fidelity Bank, it's not that 303, it's not that 403 creates this new entity, and essentially the Attorney General is becoming the client. The Attorney General is driving the boat. But this is really all disposed of in Carcia, if you think about it, because in Carcia, this court's case from back in the 80s, the then Attorney General tried to bring a criminal prosecution. And challenges were made to that, basically that the Attorney General didn't have the authority because it wasn't spelled out in the Commonwealth Attorneys Act, that type of crime. This court looked at the Pennsylvania Constitution language, specifically that the AG shall exercise powers and perform such duties as may be imposed by law. Said that's the legislature. That's not some well of authority that they have. Looked at the Commonwealth Attorneys Act, quote, shall exercise such powers and perform such duties as hereinafter set forth, and then made clear that the Commonwealth Attorneys Act is the sole source of the Office of Attorney General's powers. That's what the case stands for, and because that crime was not specifically set forth as one that could be prosecuted by the AG couldn't. Same rationale here. There is nothing in the Commonwealth Attorneys Act, and my friends on the other side don't point to anything that would say that the Attorney General can become the client, can become the party, can become the litigant in this tax appeal and put forward.
I don't think that's what,
But I think that's the end position.
they don't want to be the client. They want to be the counsel for the Commonwealth, which I believe they are.
But the Commonwealth is, in this instance, the Department of Revenue.
And counsel, if I just might clarify, when the court was referring to dual representation, they weren't talking about two contrary positions. They were talking about two representatives presenting the same, asserting the same position.
I think they were at odds with each other, factually. I think the Attorney General's office took positions that were different than the Turnpike Commission's counsel was in that case.
Okay, so in this case, the AG can be here on behalf of the department, taking a position contrary to the position of the department, if that's what dual representation means.
No, I don't think they can. I don't think they can.
Well, why could they do it in the context of the Turnpike Commission?
I may be wrong about that. I'll have to go reread it. I may be.
Well, because if dual representation, frankly, I don't know how that could be, because that would mean that the client had two different positions. That can't be.
Except, counsel, could it not be that in this, thinking about Justice Donahue's point, could it not be that such dual representation has to be accounted for in the context of two independently elected statewide constitutional officers within the same branch, unlike the federal constitution, being the governor and the attorney general? So that, I mean, I guess, is it a distinction without a difference in practice, because they're going to be heard? I guess though that your answer is, per your earlier answer to me, they shouldn't be heard, you're saying.
Correct.
But that seems anomalous. It seems to make the OAG the proverbial plant. Potted plant.
Who then represents the broader interests of the Commonwealth as a whole, the people of Pennsylvania? I understood coming into here that that was the Attorney General's job.
The Attorney General's power is specifically limited by the Commonwealth Attorneys Act. This case has never come up before. I mean, this is first impression stuff. This has never come before any appellate court or this court that I'm aware of, where the Attorney General's office has taken a position that conflicts with the position of its longstanding client. If you look at 204, shall represent, I think you hit on this, Justice Donahue, represent. It's not become the client, it's represent. Shall represent in an action which is specifically defined.
Well, representation to an attorney means you promote your client's position.
Yes.
I mean, and maybe I'm looking at it too simplistically in that regard. In answer to the question, who's representing the people of the Commonwealth? You are. Because the Department of Revenue is designated as that agency of the government to speak on behalf of the people of the Commonwealth and protect their interests in matters involving Department of Revenue
Taxation, settlements, and the like, yes.
issues.
Yes.
I mean, you're not acting opposed to the people of the Commonwealth. You are representing the people of the Commonwealth. Pursuant to your authority granted by the legislature, said this is the agency that is going to speak on behalf of the Commonwealth on matters regarding finance.
Yes.
In support, you're citing Garcia, which is not at all it's not on any of the fours with this case. That was vis-a-vis local prosecution. It's the concurrent prosecution. This is a different species of thing, and I'm still not following why this doesn't fall within the Commonwealth Attorneys Act. They represent the Commonwealth and all Commonwealth agencies in any action brought by or against the Commonwealth or its agencies. So that at the very least, why is it so clear in your favor that our court should not allow the current two-headed monster to proceed in a circumstance like this? So, I guess putting it this way, is there not enough doubt that the least harm we can do is to allow both to be heard in a case like this?
I don't think that the law, that the Commonwealth Attorneys Act or Garcia, and I think Garcia actually does control here, because the broader proposition in Garcia is that if the Commonwealth Attorneys Act doesn't specifically authorize the AG to do something, the AG can't do it. There it was prosecute a specific type of crime. Here it's representing in a tax appeal, where it's taking a conflicting position, and that's critical. And we've talked about actions. Action is specifically defined. It does not use the word appeal. My friend on the other side wants to sort of jumble this all together and say, well, everybody would understand action to mean appeal, and maybe true, but it doesn't matter.
Mr. Joel, I think and you've done a fine job, I think we're retreading the same ground at this juncture.
May I ask a question about procedure, Chief?
Sure.
And I mean the procedure in this case.
Sure.
Before the Board of Finance, did your client have counsel? I mean, who was the proponent of the position of the Department of Revenue in that case?
Office of Chief Counsel.
Okay.
So Office of General Counsel, Office of Chief Counsel.
Okay, and that is because it was an administrative proceeding, and the AG would not be involved in that proceeding in ordinary course?
Correct.
Okay.
Correct.
Now
So then there's an appeal to the Commonwealth Court. Who was representing your client in the appeal to the Commonwealth Court?
The Office of Attorney General, until the brief was filed, representing the Department of Revenue. The Office of Attorney General was. Until the brief was filed and this position was put out there that we're wrong, that we're entitled to no deference, that's not our position.
Did your client ask the Attorney General to get involved in the appeal? I mean, yes?
Yeah, that's the way it works, yes.
Okay, and when that occurred, your opposing counsel indicated to us that the department was aware that the Attorney General took a position contrary to your client's position?
Yes, that's going to the exception, and that's in the record, that it was the Office of Attorney General's position of X. That's far different than what they've tried to morph into now, which is the Commonwealth's position. And that is a major difference, and that's what we take issue with. It's one thing for the...
Intervene in the Commonwealth Court.
I'm sorry, I didn't...
Your client had to intervene in the Commonwealth Court in order to make its position known?
Yes, and that was unopposed by all parties.
Well, of course it would be. I mean, okay.
If the Attorney General had agreed with your position, you asked the Attorney General to step in represent, in my view, the Commonwealth, but whatever your view is, it's narrower than that. If he had agreed with your client's position, then what would have happened?
Then, so the way this percolated up, and I think this gets to your question, is at the Board of Finance and Revenue, Synthes and the department agreed on the law, but Synthes didn't prove its case, which happens quite frequently in Board of Finance and Revenue cases, and it just does. When it got to Commonwealth Court, they actually put proof on the table, and they proved their case. So had they represented our interest, the case is over. Synthes is entitled, I mean, including the stipulations, if we're right on the law, they're entitled to a refund, and we support that. So,
Are you going to present some argument regarding the choice?
I can. Could I make one final point on the appeal issue, and then I promise I'll move on. I had a lot more on this topic, but I'll move. I wanted to just point you all to Chesapeake Energy, which is a case where the Attorney General said the phrase trade or commerce ordinarily would mean buying and selling. Maybe. Maybe just like action wouldn't ordinarily mean appeal. Maybe. But in that case, the CPL, the General Assembly specifically defined the term, and that made all the difference. Resorting to a dictionary or ordinary usage for the definition of trade or commerce ignores and renders superfluous the very legislative act of providing a definition for those terms. We presume the legislature was aware of the ordinary meaning of those terms and chose to define those terms more precisely for purposes of the Unfair Trade Practice Consumer Protection Law. If the legislature intended for trade and commerce to be defined using an ordinary meaning, it would not have defined them. To your point about appeal, matter, which they can provide advice on matter, is a far broader topic or array than an action. Moving on to the tax provision. I agree with my friend on the other side that we have to read all the words. Pretty basic stuff. Our position does that. The Attorney General's position does not. This is apportionment. This is a business that is making sales in New York, in Virginia, in Maryland, in Pennsylvania. That's what they're doing. Sales of services. The key is, where do we locate those services? Is it where the back room, office, employees, property, real estate are, which is the Attorney General's position? Or is it where that income-producing activity is performed? Income-producing activity performed is not defined. I'm talking about 17A right now, is not defined in the statute. So the common words, the common meanings of those words: performed, to fulfill, to complete, to finish. One cannot have income-producing activity completed, fulfilled, performed until the customer receives the service. Think of a cable TV. If my cable provider is in New York, no income-producing activity is performed vis-a-vis that service to me until I get my cable signal in Philadelphia. Just the way it is. That's 17A. The Attorney General's position on 17A misunderstands what the statute is geared to do. Its position in its reply brief on page 26 is, quote, 17A is for the situation where, quote, a business conducts its activities entirely within Pennsylvania. That's not 17A.
Well,
if a business, I'm sorry, Chief Justice.
Isn't the Attorney General's position just almost just factual, that you're wrong, that where all the apparatus is to take the programming and stream it from there to, if it's over the air to the world, if it's through a cable to all those homes subscribed to the cables, it's not where it's received, it's where the income-producing activity being the creation of the signal is, which should control where taxation's paid.
And we disagree with that because of the word performed.
But all I'm trying to point out is that, and I don't know quite what the answer is, tax is not my favorite thing, but that their interpretation and your interpretation are both defensible under the words of the statute.
That's the way the Commonwealth Court read it. They read it as being ambiguous. We think that performed actually is clear, but if we assume that it's ambiguous, we should be entitled to deference. We are the executive agency charged with interpreting statute, applying the statute, enforcing the statute, implementing the statute.
I didn't mean to throw you
No, no, no,
off.
that-
I was just asking to give you
Happy
the
to
chance
take
to
any
tell
and
me
all
why I'm wrong.
questions. But that's not where I was going. So all the activities performed in Pennsylvania is not a 17A problem. That's a non-apportionment problem. Those entities are statutorily prohibited from apportioning their taxes. You never get to 17A. You never get to apportionment. 17B, they didn't like our snowplow example, okay? Came up with another one. OnStar. I have OnStar in my car. I live in York. I work in Harrisburg. For a year, I do all my shopping in Pennsylvania. I never set foot in that car outside of the state. Never, not once. I vacation in Erie. I shop in Manchester Township, whatever. I never go out.
This is a hypothetical.
This is. But this shows what 17B is geared towards. That's a 17A problem because that service is located where I'm using the service. I, as the customer, I'm using it in Pennsylvania, whether I get roadside assistance in York, Harrisburg, Erie, whatever. 17B, let's assume I live in Philadelphia. I work in New Jersey. Sometimes I shop in Delaware. I vacation in Virginia. And I use OnStar every place I go, and it's just my dumb luck that I get and I need roadside assistance one time in each of those states. Then you look at the cost of performing that service to Pennsylvania, the cost of performing that service to Virginia, to Delaware, to New Jersey. And under the code as it was in 2011, if that cost of performance to providing it to Pennsylvania is the plurality, the sale of service is located in Pennsylvania. If it's
Let
not,
me
it's
ask you
not.
again, and I may be too simplistic, and I apologize, but what occurs to me is the income-producing activity, at least I'm foolishly consistent, even consistent but foolishly so, is that what's it called, OnStar?
Yeah.
Yeah. OnStar, I don't have I used to have a GMC, and I no longer do, but I have the equivalent provided by another company. The OnStar Service Center is in India. When you hit that button, you get connected to somebody in India who services General Motors there. So the argument is but let's make it New Jersey. Let's assume GM is
Yeah, I'm assuming,
better.
I should have said that.
So,
Let's
because
assume
we
that
don't
I'm
have
serving
jurisdictional problems. The income-producing activity is where the 911 center is. That's where they person the phones. That's where they have all the technology to monitor your tire pressure and oil, et cetera, et cetera. Again, is that what the department wants me to decide? I'm sorry, not the department, the
That's
OAG.
what the Attorney General wants. Yeah,
That's what they want me to decide that.
Yeah, they want all that
And you want to
back on.
say, no, it's where you are and where you receive the services.
Correct, because
Okay.
that income-producing activity is not performed until I use the service.
You use it, okay. At least
And that's consistent with Gilmore, which this court,
Which case?
Gilmore, 2003 case from this court, statutes permitting a corporation to apportion to sales for purposes of CNI, that's what we're dealing with here, are designed to represent the contribution of various consumers and purchasers to the entity's overall sales. Specifically in Pennsylvania, the numerator of the sales factor represents the contribution of Pennsylvania consumers to the purchasers and purchasers to the entity's sales, while the denominator represents the contribution of all consumers and purchasers. So again, Gilmore gives us the framework. That's the purpose of the sales factor. The sales factor is purposefully looking towards the customer. 17 only locates where the sale is. You have to read those together. You can't have subsection 15 dealing with sales factor looking towards the customer, but then have subsection 17 ignore the customer and look where the backroom operations are. That's not harmonious reading of the statute. It's not harmonious with Gilmore. And
We're going to hear on the same topic from Synthes Counsel, so finish up so we can hear.
let me give
so
you
he
one
doesn't
more,
get
I want to give you
discouraged.
one more example which highlights the uniformity problem of the AG's position. So I'm going home tonight, I need gas. I have 2 credit cards in my wallet, one from a Pennsylvania bank, one from a New York bank. My Pennsylvania credit card is nearly tapped out, so I put 20 bucks on it, then I put 20 bucks of gas with my New York credit card. Under the AG's position, the $20 that goes, because the Giant, let's assume I'm getting it at Giant, they have a contract with both Visa companies, they get fees for every time I swipe. That fee is going to pale in comparison to the backroom operations in New York. So same transaction, same fill up, same day, just 2 different cards, and you've got different treatment of otherwise similarly situated taxpayers. That's a uniformity problem. Our reading would locate both of those sales in Pennsylvania. We avoid that problem. So,
Thank you.
for the reasons in our brief, and today we would ask that you either quash the appeal or rule in our favor on the Attorney General's inability to take a position contrary to its client, the Department, and affirm Commonwealth Court's interpretation, which is the Department's interpretation of the tax code. Thank you.
Thank you. Mr. Gallo.
Good afternoon, Your Honors.
Last for what's been a long term, but certainly not least.
Last but not least, thank you. And certainly in the unenviable position of being last on your docket this week. But be that as it may, good afternoon, Your Honors, and may it please the Court, my name is Frank Gallo. I'm here on behalf of Synthes, Apelt, Synthes USA Headquarters, Inc. I'm joined by my co-counsel, Brent Beisel, and I'll just jump right into it. Synthes' primary interest in this case is to be treated fairly and uniformly with all other similarly situated taxpayers. And from Synthes' perspective, there are 3 primary issues before this Court. One is who's in charge. The second is who's correct. And the third is uniformity, right? And we understand the Court would like us...
Overarching that you get your tax refund.
An overarching tax refund, yes. And we understand the Court would like us to focus on the first 2 of those issues. But having said that, I will say that the uniformity issue, in our view, is inextricably intertwined with the who's correct issue. So I would need to explain just a little bit about, in explaining our statutory position, I'll have to at least explain how uniformity fits into that statutory analysis. And the reason is, that in short, regardless of the interagency dispute between the 2 sides, regardless of the competing statutory interpretations between the other 2 sides, uniformity dictates that Synthes must be treated the same as all similarly situated taxpayers. And what that means that either way, Synthes tax must be computed under this so-called benefit received method. So if I could jump into the first issue, and I'll be brief because it really doesn't impact us as much.
I appreciate what you're saying, but if this Court decides that the proper method is cost of production, then presumably, at least prospectively, all taxpayers will be treated the same, and that's the method that will be used. Now, retroactively, there's not much we can do with closed cases.
Right, and it's interesting though, this case is involving, for us, it's just 3 tax years. And what we've raised is that there's a uniformity problem, right? That if you find that the law is what the agency says, then you would you'd apply the benefits received method and we'd have no further dispute. But if you apply the Attorney General's version, the cost of performance interpretation, at least with respect to us, that would work a uniformity violation. And the reason is that
you're treated disparately from everybody else in a similar tax year that didn't find themselves betwixt and between these 2.
Exactly, and most importantly, we stipulated to that fact. We stipulated that the Commonwealth applied, and the Commonwealth being the Department of Revenue, I guess in this case, the Commonwealth applied the benefit received method to every similarly situated taxpayer except for us, right? And the parties stipulated that Synthes met its burden of proof. So even if this Court, again, decides in favor of the AG's interpretation of the statute, we think that there's no, under the unique facts of this case and this Court's prior precedent, this Court would be required to rule in favor of us in terms of applying the benefits received method. And the reason is this Court's prior precedent tells us that this is the right result, right? In this Court's prior decision in Molycorp and also a 1931 U.S. Supreme Court decision in Cumberland Coal, which was itself a Pennsylvania case. The issue was uniformity/equal protection, went through the PA courts, went up to the United States Supreme Court, and the Supreme Court told us, and I'll paraphrase a little bit here, when applying the law as written conflicts with uniformity, uniformity wins. So, again, regardless of what the correctness of the statute is, maybe going forward, or even for this year, regardless of the correctness, the statute must yield to the uniform application of the statute. And again, that's what this court said in Molycorp.
And that's your narrow issue.
That is really our narrow issue, is that either way, whatever you decide about the two issues, we want this case affirmed, whether it be, on the merits or whether it be as a matter of uniform enforcement.
16.1 prospectively, which was added in 2014,
It
solves this issue.
Yes, and that's just it. And that's why it's not a go-forward issue for us, and we're really not looking to get an answer on the issue, or it just doesn't affect us because it's not go-forward. We have 3 tax years, and effective, you said, Chief Justice Behr, effective 1/1/14, the statute says pretty much what the department is arguing. It's a benefits received type test. So again, this is sort of an isolated situation that I think is resolved in sort of this narrow facts, narrow case, narrow dispute. And to that end, we do respectfully suggest, I know that you brought up 2 issues for us to discuss today. The third, what you didn't bring up, was the uniformity clause, and we do respectfully suggest that this court could decide this case based on uniformity, based on the very unique facts of this case and the very unique stipulated record in this case, which I think as a self-contained document establishes the violation of uniformity in this case.
I think you perceive uniformity as your most predominant justification. And that may well be, just really briefly, do you think that the statute, putting uniformity aside, that's what I'm trying to do here, is ambiguous or unambiguous?
We actually do not, and that's, again, another oddity of this case. We actually do not think that the statute is ambiguous. And, sorry, go ahead.
Well, no, I was just, in all the hypos that the counsel for Mr. Joel for the Department of Revenue were spinning, were you agreeing with his result that, if you hit the button on OnStar in Philadelphia and there's this massive service center in New Jersey, the income's produced where you hit the button rather than where you respond to the button?
And again, that, Your Honor, is the oddity of this case, and why I bring up that either way, what you decide, the decision below should be affirmed. And the reason is that, to be truthful, that we've never endorsed the department's position. We've said, if the department's position applies, then here is the result. If the department's position doesn't apply and the Attorney General's position applies, well, then we have this giant uniformity problem. And that's why we've proceeded to...
Coming back.
to
Fair enough.
So, and, truth be told, we would agree with much of, other than the uniformity analysis, we'd agree with much of the Attorney General's discussion about how the cost of performance section should be interpreted.
I thought you were Switzerland up till you said that.
I tried to be, Your Honor, I tried to be.
All right.
And notwithstanding this is important to your client because some millions of dollars are at stake, it's an encapsulated problem because the legislature has secured it for 2014 and onward.
That's right. And again, as I started off, our primary interest in being here today is just to be treated fairly and equally. All other taxpayers, the department would admit, all other taxpayers got the benefit of this benefits received method. Okay, fair enough.
Anything you'd like to add at all? We got it, frankly. Did a good job.
No, I think that's it, Your Honor.
I'm glad you had the opportunity to speak because I think the uniformity is worthy of deep consideration, and you are the only person that raised it, so you were necessary. Thank you.
All right, thank you.
All right, Brian, we will call this session a wrap.